This hearing is in the matter of case number CFI 090-2022 and is being held by way of video conference before Justice Rene Lemiere. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by Al-Tamimi and Company. Lead counsel is Mr. Tom Montague Smith, KC. The defendants are represented by Hamdan Shamsi lawyers and legal consultants. And the lead counsel is Mr. Robert Whitehead. Thank you all.
All right, thank you. Can I start by asking for an estimate of how long you think you're going to be?
Certainly. For my part, Your Honour, I would anticipate needing around 2 hours, possibly another 10 minutes or so.
Right. Mr. Whitehead?
Same, Your Honour. I would probably just more be sort of 2 hours, yes.
All right. Well, what I propose we do is that when you have finished your submissions, Mr. Montague Smith, we take a short break. Now, I know, Mr. Montague Smith, you're in London, so it's about 7 a.m. for you. Mr. Whitehead, where are you?
In Dubai, yes.
In Dubai, okay.
Yeah.
All right. I was thinking how long, depending on what time of the day, what might be an appropriate break. 20 minutes?
Certainly. We're in your hands.
All right.
Very good, yeah.
All right, well, let's do that. Mr. Montague Smith,
Thank
you have
you,
the
Your Honour.
floor.
Thank you very much. And hopefully Your Honour has had an opportunity to read the skeleton arguments from the parties, so has some of the background. You will have seen, Your Honour, this is the bank's application for immediate judgment on the claim, and we say this is a very straightforward debt claim. Now, while the debt itself is quite large, it's up to $55 million at the moment, the issues that you're faced with are not complicated and they don't require a trial. And in short, we say the bank extended credit, that's not disputed. The facility is repayable on demand, that's not disputed, albeit my own friend seeks to impose some implied terms, and I'll deal with those. Those are short issues of law. We can deal with those. The loans were called in March 2022, and they have not been repaid by September 2022. And so what happened then was the bank sold the liquid securities that it held, and it set off its receipts against the debt, and the result of that is you have a debt for $55 million. And then in relation to the second defendant, you've got a guarantee, and there are a couple of short issues of law in relation to that, and I will deal with those, but you can resolve all of that today, and we say that once you do, you will find that both of the defendants are liable for this debt. Now, at the time of the actual events, there was no real dispute about that. It may be that there isn't actually any dispute about the principle of liability, because at the time, the defendants offered to pay off this debt at the rate of about $3 million a month, was what they were proposing. In fact, they've paid nothing. Now, in their skeleton argument for today, if Your Honour has a copy of that, it's in the bundle, yes. But if I've got it separate, and if you have two, then
yes, I have a hard copy.
Thank you. If you were to turn to page 12, please, and just have a look at paragraph 41 and what is said by my learned friend here, and it's 3 lines down at the end of that line. My learned friend said the defendants do not deny that they are required to repay the claimant. So and as we go through the issues that are raised in the defence, I'll explain to Your Honour why the defendants are driven really to that admission, because there is not, we say, a real defence here, that there are a series of assertions which don't amount, we say, to anything. Now, you may also have seen, if you've dipped into any of the correspondence, Your Honour, you may have seen this. There's in the process, in the course of this facility, there were a series of promises that money was coming, a series of margin breaches, a series of statements that further security was coming, that some third party would come in, pay off the debt and take their portfolio, and that all this was going to happen imminently. And that becomes something of a theme that you will see in the course of the correspondence. And I will take you through some of that, and you will see that what is being asserted by my learned friend in his skeleton argument, and to some extent being asserted by his witness, just is completely contradicted by the documents. But you don't really need to decide much of that if you're with me on the law. But I think what we say is that in their defence, the defendants seek to complicate this rather simple debt claim, and that when you go through each of those defences, you can see that there's nothing in them. And this is precisely the sort of case that the immediate judgment jurisdiction was designed to deal with. In relation to the principles for immediate judgment, Your Honour will presumably be familiar with those, and you will have familiar procedural devices in other courts and other forums. But the principles shouldn't really be in dispute. They were confirmed again by the Court of Appeal in this court in a recent decision in the EMBD and Advanced Facilities case. And we've set out the relevant passage in full in our skeleton argument at paragraph 42 and onwards. But it's set out there for Your Honour to refer to. But just the absolute critical parts of the test. The question for Your Honour today is whether there's a real prospect of defending the claim, that's real as opposed to fanciful, realistic, but that it requires a more than arguable claim. It's not, you can't just turn up and say, I've got an arguable claim and I might be able to get somewhere with it. It has to be real, it has to be genuine. And it is right, the court should not at this stage be conducting a mini trial on the facts. You can decide, and the authorities suggest you should decide short points of law at this stage. But in relation to facts, you are not required to take every assertion of facts simply at face value. And if in this case you agree with me that it is clear there is no real substance to an assertion of fact, particularly where it's contradicted by documents, contemporary documents, then you can dismiss the defence on that basis at this stage. And as I say, if it's a point of law or construction, then the court usually should grasp the nettle. The EMBD case itself was quite a good example of this. And the Court of Appeal confirmed the judgment of Mr. Justice Cook below. But in that case, there was an allegation. It was also a banking situation, but there was an allegation of words said at a meeting immediately before the lending was entered into. And Mr. Justice Cook was able to find that those words were never said. And so you had a face value assertion of a fact, and then the judge was taken through and looked at the material surrounding it, and was able to find confidently that there was no real substance in those allegations. There were a number of other issues in that case, and it would have succeeded, the application would have succeeded on other grounds in any event, but it gives you a feel for the approach I suggest of this court, which is robust. It is to say, look, if there really isn't an issue to be tried here, we don't need to spend 2 years doing it. We don't need to spend huge amounts of money doing it, particularly when, as in this case, you've got a situation where you have a very substantial debt, which is increasing with interest over time, and we simply don't know whether or not the defendants are going to be able to meet it. Now, my learned friend says in his skeleton argument repeatedly that there are things that need to be investigated at trial. Now, a number of the points he raises are points of law. So in particular, he says, well, at trial, we need to investigate whether or not the bank had a duty to do certain things. And those are issues of law which can, and we say should, be answered today. Other issues that my learned friend raises are simply irrelevant. And I just make one point here, or 1 or 2 points here. If Your Honour again has a skeleton argument and was to turn forward to page 14, you will see under heading 3, paragraphs 54 and onwards, my learned friend deals with the misrepresentation claim that's advanced in the pleadings. Now, that is not part of this application. So there are two parts to the claim as pleaded. One is the debt claim, and that's what we're seeking judgment on today. The other is this issue about, you will have seen the Landstone bonds in particular. And we say that the defendants provided those bonds as security and got money as a result, but they hadn't paid up the bonds. And so the bonds were not, they were in default. You don't need to decide those issues.
Is that at all relevant for today?
The question of the bonds and the valuation of the bonds may become relevant in the sense that my learned friend says, firstly, that we had various duties about setting collateral and margins, and that we breached those duties. And so we say there were no such duties, but even if there were, if you look at what happened, the allegation just isn't made out. So he says we unilaterally reduced margin loan to value ratio from 70% to 30% or 80% to 30%. And in fact, that's not quite what's pleaded, but that's what he says in his skeleton argument. If you look at the documents, you can see there's no truth in that whatsoever. It just doesn't happen. And we can show you that because you can see what happened. You can see the collateral valuation and the margin statements, and I can show you the one before and the one after, and they're the same.
So is this what the defendants say, that you revalued the assets as a result of which the ratio of the assets to the loan became only 30%, and as a result of that you required some further payments, either further deposits to be made or the loan to be reduced? Is that the way it works?
Sort of. We say there isn't a coherent allegation here. The setting of margin requires two things. The first is the valuation of the assets themselves, and then the second is the attribution of a loan to value percentage to that asset. So I might say you've got 100 securities in my pocket. I value those securities at $1 each. So you've got $100 worth of collateral, but your loan to value ratio is 70% because those could fluctuate with the market. So I'm going to allow you to borrow $70.
Yeah.
So there are two elements to that, and it's very unclear what actually is being said by the defendants. In the first instance, they appear to be saying what Your Honour had said, which is that it was about valuation of the collateral.
Right.
And of course, some of the collateral varied in value because it was market securities, and so they're tradable securities and you get the value on the day. Some of the collateral was just attributed a flat notional valuation, and the Landstone bonds in particular were not liquid. So these pay out at the end of, they pay out in coupons, but they pay out fully at the end, and they're not tradable entities that are listed or anything like that. They are simply, you can buy them and sell them, but they're negotiable, but you have to do that.
This may not be important, but I saw references to the coupon. Was it under the terms of the facilities loan arrangements, were the defendants or the first defendant obliged to pay the coupon to the bank?
Well, yeah, we say yes. You don't need to decide it, no, okay. And we don't make a point on it particularly for today. But the way it works is that all of the securities that were handed to the bank fall within the terms of the charge. So you'll see there's a charge. So everything is there to secure the lending. Anything that we have in our hands that belongs to them is there to secure the lending. Now, the coupon wasn't paid, and initially the defendants said, well, we have received, Mr. Juma has received the coupon and we will pay it to you, the bank, and it was all a big mistake and they should have paid it to you, the bank, but they paid it to him. And then they say we will pay it to the bank, but it never arrives. And then if you fast forward to the end of the story, we speak to the bond issuer, LAMAG, and they said, no, we've never paid a coupon on the bond. Why not? Because they didn't pay for it. Number one. And then we spoke to the insurer, and the insurer said the bond's not insured because it wasn't paid for. So we don't know what the true position is. It'd be rather odd if the bond issuer was to tell us that and it wasn't true. But if that is right, then there never was any coupon and it was all lies from the beginning. But you don't have to decide any of that today. And in fact, my learned friend spends a lot of time on this issue of margin calls. And he says, well, Mr. Dr. Khan, who gives his evidence, says, oh, well, the bank forced a default. And all of that actually is irrelevant because this was on-demand lending. It was all on-demand lending. And so it doesn't matter whether they were in margin default. And I'll show you the relevant terms. But we were entitled as a bank to set any margin we liked in any way we liked. We could take whatever risk we wanted. We can value the collateral in any way we like. So all of it is completely irrelevant. And that is why my learned friend has to succeed on his implied terms case to get anywhere on this. Because unless there's some sort of implied term that we're restrained in our ability to call in the loans, then we've just called them in and the debt is due. But what my learned friend says is that he says that it's just not true. It's blatantly false, is the way he puts it in a skeleton, that they were continually in breach of margin. And that, we say, is actually revealing, because he refers to his own client's evidence in relation to that, Dr. Khan's witness statement. And we've produced quite a lot of evidence on margin and margin reports and so forth. And when you actually look at the contemporaneous documents, you can see that the defendants were quite plainly in persistent breach. It's just straightforward. And I wasn't going to take you through that in too much detail. One of the allegations that is made is about one Swiss bank, and that it said the bank wouldn't allow a transfer to one Swiss bank. And as we go through that, you'll see some of the statements to do with margin. But I'll just show you one or two pages, if I may, from the bundle, just to give you a flavour of what you're dealing with here. If you were to go to page 552, Your Honour.
Yes.
And you'll see there that at the bottom of the page, you'll see an email from the bank, and it says, this is sent to the CFO. That's Dr. Khan, who gave the witness statement for the defendants. It says, "Dear sir," and then 3 lines down, "as you already know, the account has been in margin situation since 31 December 2011 and is beyond any of our control to hold back any sell action." And then Dr. Khan asks for the calculation, and then eventually, all the way, we're now in middle of February, 15th of February, he clears it. And so they've been in margin breach by this point for about 6 weeks, and there's no dispute there that that's happened. That's just the position that's, and then if you go forward to page 559, you see they're back in breach. And again, there's no dispute. So in the middle of the page, you see an email from the bank saying, "There's your 1.1 million back in margin deficit." Answer, "Well, we'll replenish it, or we'll sell the open positions," and so forth. And that's 7th of March. So that's only a few weeks later. And then if you go forward to page 562, you'll see the answer to that 7th of March email. So 563 is the email we've just looked at, which is telling them about the margin breach on the 7th of March, and they're still in breach on page 562 on the 9th of March, and all of that carries on up to page 561 until the middle of April. And so as we go through, as I say, the allegations about one Swiss, you will see that they are consistently in breach of margin throughout. And by this time, on the 11th of March, was when the demand was made for repayment, and it was said that the money should be repaid. But you don't have to decide whether or not there was margin breach, because it's an on-demand facility. But we said is telling. It gives you some insight into the way that the defendants have dealt with this. They're making unsupported assertions that just fall apart on the first inspection. And again, you're not obliged simply to accept those assertions. You're entitled to look at the documents, particularly where here the assertions are actually largely about communications that were made between the parties in writing. So that's how the parties communicated. You can just look at the writing. And then the final preliminary point that I'd make before I get on to the claim and then the defences is, as Your Honour knows well, this isn't an inquisitorial exercise. And so it's not enough to offer up points that you say require investigation. The defendant needs positive defences. And one of the points that the court courts have made repeatedly on these sorts of applications is that it's not enough to say it all needs to go off for trial because something might turn up. Those are the words that we used in the EMBD case, and it's the references. I won't take you to it, but it's page 1344, paragraph 32.
Sorry, 1344.
Yes, that's correct. Paragraph 32.
Paragraph
32.
Thank you.
32. Thank you. So that was as a sort of preliminary opening, just to explain the test and how we say you should approach these issues. And then what I was going to do was deal briefly with the basis for the claim in outline, and then go through each of the defences that are raised. I don't in that. I will show you some of the evidence, but I won't take you through the facts in detail because I know that you've managed to read the skeletons, and I'll just show you some of the key features of it, though. If we go, please, to page 194, we'll see the facility letter.
Yes.
So this is the letter that was sent on the 5th of October, and the bank is offering credit facilities, and you will see there in the first paragraph that they are offered on an uncommitted basis. Do you see that in the third line?
Yes.
So uncommitted means on demand, and they are in any way, as it says, subject, second line, subject always to the bank's overriding right to demand repayment at any time and the availability of funds. And the terms and conditions are set out in two documents. You will see reference there in the second paragraph to the GCTFA, the CTF agreement, as we've called it, and the standard terms, or the services agreement. And I'll show you some relevant parts of that briefly in a moment. But if we go down then to page 197, you'll see the facility that is being offered. Again, it is on the first passage, their paragraph there, on demand, uncommitted, revolving short-term advances overdraft facility, up to 240 million euros, with also a trading facility of 5 million euros. So it's always uncommitted, it's always on demand. Then if we go to page 200, you see the beginning of the services agreement. Now, Your Honour, I've set out in our skeleton argument some of the relevant terms of the agreement on which we say are material to this, and so they're all set out there at paragraph, I think it's 59 of my skeleton, but I'll take you through them in the bundle just so you've got them, the markup and reference, not all of them, but just the relevant ones for these purposes. The first one is on page 206. And you will see it's quite a long passage. And you'll see on the second line of this first paragraph, the availability and or continued availability of any service shall be subject to the bank's consent in its sole discretion, and then also to the fulfillment of such conditions as the bank may require. And you will see further down there. Sorry, I've marked up a previous version of this bundle, so my markup has disappeared. So many apologies for this, but you will also see that the bank in that clause reserves the right to cancel, suspend. There it is, the final sentence of that passage, of that first paragraph. The bank reserves the right to, at any time and from time to time, with or without notice or cause, cancel, withdraw, suspend, vary, change, add to or supplement any one or more of the services. So it's properly on demand. And then page 226. Yes. You will see clause section B and clause 1 of that, types of facilities that are offered. You will see that it says, upon request from you, the bank may, in its discretion, make available any or all of the following facilities to you. So it's all at the bank's discretion. I'll just show you 2 or 3 more. two more, in fact. Page 235. We're now in the CTF terms. And it's in relation to overdrafts, paragraph 7.1. The bank may at its absolute discretion grant to the client overdrafts on the client's account and on such terms and conditions that it may oppose. Where an overdraft is permitted by the bank, each principal amount advanced by the bank at its sole discretion shall be payable by the client immediately upon demand by the bank, together with interest accrued and so on. And then if we go finally to 271.
Yes.
You will see in section A, again, it is the first paragraph, the bank may at its discretion offer credit and trading facilities. Any credit and trading facility offered shall be on an uncommitted basis unless otherwise specified and subject always to the overriding right of the bank to demand repayments at any time. So it's just an on-demand facility. If we go then please to page 311, you see there the demand, which is made on the 11th of March. The bank gives notice that it's closing the account and terminating the agreement, and it sets out there what the sums outstanding were in 3 different currencies, you will see. So as at that date, all of that money is due immediately. And then the bank, however, gave a deadline until, you'll see it in bold in the second paragraph, 11th of April 2022. If we go over the page to page 312, you'll see by the 12th of April, nothing's been paid. So they give notice that they will liquidate securities if there's no repayment. And they say they'll do that if it's not repaid by the 26th of April, 2022. Of course, that doesn't happen either. There's no liquidation at this stage. Page 313, you can see there's a demand of 15 June 2022. Now the sums outstanding had been reduced by this time, but they hadn't been cleared. But again, there's another warning that they will liquidate assets which are held as security. And then we get all the way down to September 2022, and we'll see a little bit about the intervening period as we go through the allegations that are being made. But as I say, we say you don't really need to make any decisions about that if it's not necessary for the judgment. But by September 2022, there's still been no repayment, and so the bank liquidated the securities. And if you want to go to page 317, and you may need to rotate the screen, which is always dangerous, I find, because the rest of the bundle goes with it. But that's the statement of account at the end of May of this year, and you'll see.
Just bear with me a minute whilst I hope I'm getting it rotated properly. Upside down. Yes, okay.
Very good.
Now,
so that's the statement of account at the end of May 2023. And then on page 324, you've got the outstanding balance as at that date, which is a little over 53 million. Now that's the statement that was produced at the outset of this application. We've got the latest statement in the bundle, and I can give you the page reference for the number. It's 1562, and the total outstanding at the moment is 55,193,715.33, and that obviously continues to accrue interest. So that's
I'm going to ask you, Mr. Montague-Smith, that later to tell me if I find for you what the amount should be.
Certainly, thank you. Very good. And then, so that's the position as to MARJ Holdings. And then you've got Mr. Juma's position. Mr. Juma provided the guarantee. You'll see that on page 292. And That's the beginning of the guarantee. Page 293 sets out what's being guaranteed, and it's the guaranteed obligations as defined. Those are set out on page 294, and they include all obligations owed by Marj Holdings to the bank. That is dated 6th of October 2021, and there's an issue about that, which I'll come back to, but you will see on page 304 of the bundle that, and this is potentially relevant, the document's been signed, sealed and delivered as a deed by Mr. Juma, and that has been witnessed by Mr. Sani, from whom we have a witness statement. So we say, very straightforward, you've got the debt, you've got the demand, there was liquidation of securities, which reduces everything to the 55 million. You've got the guarantee and nothing's been paid. Very little of that.
Now, as I understand it, what is said by at least the second defendant about that is that Mr. Sani didn't attach his signature at the same time that, or immediately after he witnessed it. And no doubt I'll be asking Mr. Whitehead for some authority or some principle or some reason why that invalidates the deed.
So as a matter of English law, there is a requirement for deeds to be witnessed, but that's introduced by statute, which doesn't apply in Singapore. So the whole thing. Yes.
Well, that raises an interesting point.
Yeah.
This is all governed by Singapore law.
Correct.
I have no evidence of Singapore law. So am I then to assume, in the absence of any evidence of Singapore law, that it is the same as local law?
It's not quite like that in the DIFC. In the DIFC, we do it much more like arbitration. So I think there's a consent. There's the approach is effectively that we don't necessarily have any hard assumptions, and there's a Court of Appeal decision on this. You do not need expert evidence of foreign law, but so we do it by submission. You can order it if you think that there is an issue which would turn on it, and you can get that assistance if you want it. But the Court of Appeal has said you don't need it, and that's been that's been.
I don't suppose you have that reference to hand, do you?
Yeah, it was one of mine, I'm afraid, so I should know, but I can never remember the cases because it was anonymized. But in the EMBD case, I think they revisit that principle. But I can certainly produce that. But no, there's the way we approach expert evidence in this court is it's called the international way in the judgments. Now, in that said, if one's going to suggest that there is a principle that invalidates or avoids a document, you need to, as you say, produce the principle and explain why it applies. Now, in the position in England was that until 1989, deeds were governed by the common law. And so all that was changed by a statute. Now, the Singapore courts apply the common law, but they don't have the statute. At least we haven't been able to find one. So it's back to the common law principles. My learned friend says there's a problem associated with that. He doesn't actually produce any authority at all. So we've had to sort of backfill what the argument might be. And it seems to be that. But even under English, we do deal with it as if the statute applied anyway. And what the statute doesn't say is anything about who can witness and when they have to attest. They can attest later.
It must be witnessed.
Correct.
And Mr. Sani must be present when Mr. Juma executes it, but I'll wait. So far as I'm not aware of any authority or principle that says the witness has to sign it at or immediately after.
No.
No. So Mr. Whitehead, no doubt, is taking that on notice.
Your Honour, yeah.
Witnessing isn't even a feature of the common law. That's the point, though. I mean, it doesn't actually even arise. But even when it does arise, then there are these other points. All right. What I was going to do.
As I understand, as I remember it, under the common law, the ultimate test is whether it was intended to be executed as a deed. Is that right?
It needs to be signed, sealed, and delivered.
Yes.
That's the requirement. And so there could be wranglings about whether or not, for example, an appropriate seal was applied. and what amounts to it. If we look at page 304, though, I mean, that the point isn't raised, but you see the little circle that is applied. That is, as a matter of Singapore law, sufficient to amount to a ceiling.
Your Honor, I would just stress that we're not Singaporean lawyers, so we need to be very careful here.
I'm sure my learned friend can make his submissions at the end of mine.
Yeah.
And I suspect that he'll give me that.
Yeah, take it on notice, Mr. Whitehead.
Yeah. Okay.
It might be better if you muted his camera instead, just so that he's not tempted to make any more inappropriate interventions. But in any event, it's for him to make out the case that there is some defect here.
Yeah.
So what I was going to do was then deal with the defences that are raised, and the ones you should be most concerned with, obviously, are those set out in the defence. We've summarised the defences in the skeleton argument, and I'll take you through them one by one. In my learned friend's skeleton argument, he seeks to introduce some new defences which are not pleaded. We say you should stick to the defence, but there's in any event nothing in these new points in any event. And I'll pick up the points that he raises in his skeleton as I go through the defence. The first thing that the defendants do is that they deny that the facilities were repayable on demand at the bank's absolute discretion. So what they say is that the rights and discretions which the bank enjoys under these agreements, they're all subject to implied terms, and those implied terms restrict the way in which they're entitled to exercise those rights. And that, they say, applies to the bank's right to demand repayment, its discretion as to whether to make advances and how to operate the facilities, and its right to demand margin and to value collateral. And that's all set out in the defence at page 28 of the bundle at paragraph 9.2. But you can see there the sort of way that consistently they try to introduce these implied terms. Paragraph 9.2, for example.
So what page is that on in the bundle?
Page 28.
Yes.
So that it's a consistent plea, but I'll just show you one of the ways in which it's produced. So they say the wording of the facilities letter is admitted. In particular, that's responding to the pleading that it was on demand. However, it's denied that the claimant had an unfettered or absolute right or discretion to demand repayment at any time. And then the critical thing they say is they explain why at 9.2, and then you'll see at the bottom of 9.2, they say it's an implied term of each facility documents, and explain why, that the claimant would exercise its discretion to demand repayment honestly, genuinely, and in good faith, and in the absence of arbitrariness, capriciousness, perversity, and irrationality. And this point is picked up in the skeleton argument. My learned friend puts it differently, paragraph 22.1 of his skeleton arguments. He says that the overriding rights and powers of the bank should be treated by the party exercising it, he quotes, with utmost discretion, and then the exercise of this overreaching power should not be unbridled, resulting in arbitrary actions. So he focuses on the arbitrary aspect. So it is put slightly differently, but it seems to be effectively amount to the same thing. And so the first question for Your Honour to consider will be whether or not these terms can be implied. And I'll explain why these sorts of terms are sometimes implied into contractual discretions and show you the cases which say that doesn't apply in a banking arrangement like this. The second thing, sort of term that they try to imply, is they say that the bank was required to comply with regulations, so DIFC regulatory law. They say that should be implied into the contract. Again, I'll show you the authorities which say that that's just not right. And then third, they say that the bank agreed to supply its services with reasonable care and skill as a matter of an implied term. And again, we say that can't be right. So the first issue is whether any of these implied terms can exist. And then I'll go on to look at the questions of breach of obligation, And just so you've got them in mind when we look at the implied terms, there are effectively 3 categories of breach that are alleged. And the first, which is only really faintly advanced in the defence, but does feature in the skeleton, the first argument is that the bank only made half of the proposed facility available to the first defendant at the outset. And the bank says that's because it didn't have enough security. And the defendants say this was a breach of contract by the bank. But no loss is alleged as a result of this, although my learned friend does allege some in his skeleton argument. So it's far from clear where that really goes. But that's about uncommitted lending, as we put it. So it turns very much on the implied terms. The second is this point about revaluation of collateral and all of the margin defaults. And then the third category is about these allegations that the bank refused to transfer the portfolio of the first defendant out of the bank to a third party. They say that was a breach of these implied obligations. So I'll start with the duties, if I may, and then look at the breaches. Now, this is a pure matter of law. There's no factual issues that arise in relation to this. Your Honour will be well familiar with the common law approach to the implication of terms into contracts. You start with the express terms, and then you ask whether the proposed term is necessary to give business efficacy, or so obvious as to go without saying. But, and this is the cardinal rule in the Marks and Spencer case, you cannot imply a term that's inconsistent with the express terms. And in the present contract, there is an agreement that there are no implied terms. So that does for all of these. That's page 206 of the bundle. And it's in the page 206. So we're in the services agreement here, clause A2. And the contract says you further agree.
So whereabouts on
the
page?
Sorry, it's 1, 2, 3, 4 paragraphs down, the middle of the page.
Yes.
It says you further agree that subject to any duties or obligations imposed by mandatory applicable law, which the bank cannot derogate from, the bank owes no other duties or obligations to you, save as expressly set out herein, and that no implied duties or obligations shall be imposed on the bank under or by reason of this agreement. So there's an express exclusion of implied terms in the contract, and that we say is really the beginning and the end of it. It's perfectly fine to exclude implied terms by agreement. Now, clearly, sometimes terms are implied by law in certain types of contract, but there's no allegation to that effect. This is just the common law implied as in fact, not implied by law. So that's the first point. The second point is that these sorts of duties are not the sorts of terms that you would imply into these sorts of rights. So what's contended for in the defence is often referred to as the Braganza duty from the Braganza case, which Your Honour may well be very familiar with. Mm-hmm. So where a party is given a discretion under a contract, it may be subject to the duty not to exercise that discretion arbitrarily, capriciously, and for the wrong purposes. But that's been developed since the Braganza decision. The reason why these duties arise is because the parties have agreed that one of the parties will act in an impartial role, effectively. One of the parties will act as the assessor of facts or the assessor of some sort of decision making, and they intend that the decision will be made in a way that's broadly neutral. That's the Braganza duty. And the reason it arises is because, as the Supreme Court put it, the decision maker is then put in a position of conflict, and so their discretion needs to be controlled. And so what's happened since Braganza is that parties have made serial attempts to try to apply that duty to water down contractual rights in all sorts of contracts, in particular termination rights and things like that. And the courts have confirmed that there is this distinction between Braganza type duties on the one, rights and duties on the one hand, and absolute contractual rights. And that includes rights to terminate a contract. Those are not subject to Braganza, and also to similar types of rights, including rights to terminate a role under a contract, for example, or the right of a bank to demand repayment under a loan, or to refuse to continue to provide a facility. There's lots of examples of this throughout the common law.
Is it different to imply a duty of good faith with the content of not acting for some ulterior or improper purpose?
It's a very similar approach. It's solving a slightly different problem. So the duty of good faith, the Yam Seng type line of authority, arises in relational contracts, but that's been, again, slightly whittled away. This is not a relational contract. This is just a lending agreement. So it's not a sort of joint venture that's going on here. We're just lending you money. So there's no argument that there's a generalized duty of good faith implied through this sort of Yam Seng line of authority. Now that can arise in certain banking relationships, but that's not the way that the case is put. The argument is that this is a Braganza type duty, that there's an implied term restraining the exercise of a contractual discretion, and that comes from various factors, including the fact that the exercise of the right will affect both parties. But the way the authorities put it is they say, well, of course, any exercise of a right is capable of affecting both parties. So that can't be the test. The test is whether or not the intention is that they'll act in a neutral way. Now, there is a decision. I've set out some of the relevant authorities in our skeleton argument. We've provided them. I don't propose to take you through all of them unless you'd like me to, but I was going to show you one from the DIFC, which deals with this in terms, which is the Union Bank of India case. And you can find that at page 1393. And it's paragraph 116. This is a decision of Lord Glennie. You'll see at paragraph 115 the attempt to introduce into a banking arrangement, a facility, this sort of Braganza duty. And you'll see reference at the end of paragraph 115 to the right that they're trying to restrain, being the right to the discretion to make the facility available to the borrower. And then at paragraph 116, he rejects the argument, and he says, one can readily see that such a term may be implied into a decision-making process in some circumstances. But in a case such as the present, the decision whether to continue to make the facility available to the borrower after the annual review period is one to be taken by the bank in its own interests. I see no reason why, making that decision, the bank should be constrained by a concern as to whether making that facility available to the borrower is or is not in the borrower's best interests, and goes on to say effectively that when you have an on-demand or an at discretion facility, of course, everybody anticipates that it will continue after day one. But if on day one the bank says, no, I want my money back, well, that's the transaction that the customer has entered into, and there is nothing that can be done to restrain that. Now, this is a very different case that you're faced with, because you had a facility that ran from October until March when it was called in and notice was given to terminate. And so there were very good reasons why the bank has called in this loan. But the bottom line is that their right to do so is simply not restrained by the sorts of duties that the defendants are seeking to introduce. So in this case, there's no real prospect of establishing that the bank's right to demand repayment was constrained by any of these implied terms, quite apart from the express term that excludes it anyway that I showed you earlier. And that, we say, is another reason why none of the other implied terms can work either in relation, because of this sort. Because if the bank can refuse to advance credit, it can also refuse to advance credit unless particular conditions are met. So if it has an overarching discretion, then it can impose whatever conditions it likes as a matter of logic. And we have these express terms saying that the decision whether to advance credit is at the discretion of the bank, but there are also, coming on to the sort of second way in which these terms are said to impact the rights of the bank, there are also express terms to the effect that the bank can impose any requirements it likes as to collateral and margin. So there are express terms to that effect. We go to page 216, I'll just show you those. And it's clause A17, margins, collateral and security. It may be worth reading the whole of this clause at some stage, but just to show you the relevant parts, you'll see that just underneath the heading margins, collateral and security, the bank may from time to time require you or a security provider, and you agree and shall procure any security provider to agree to provide security or collateral or both in such form as the bank may in its discretion require, or maintain such margins or make deposits, you can see, as the bank may in its absolute discretion consider appropriate as security for all your present and future liabilities to the bank, and so forth. If we skip the next paragraph and go down to the one below, you'll see, unless with the bank's written consent, security, collateral or margin so provided is not to be withdrawn, sold, pledged, transferred, charged, disposed or otherwise dealt with until all amounts owing by you to the bank are satisfied or paid in full. That's relevant to the question of portfolio transfer, and I'll come back to that in a minute. But if we go over the page to page 217, again, we can skip the first paragraph, but if you look at the second paragraph, it states, the collateral value ascribed to each item of collateral furnished shall be calculated as a percentage of its market value. Such percentage and market value shall be determined from time to time by the bank in its discretion. The bank may, in its discretion, ascribe a zero collateral value to any item of collateral. So that really is just an incident of the bank's right to refuse to loan at all. But even if those provisions stood alone, they wouldn't attract this implied duty. They're manifestly for the protection of the bank. The bank is being permitted to decide how much to lend by reference to what it considers to be the value of the collateral, and therefore to manage its risk profile. And that's not a neutral role. So there are, in our submission, those points do really for the vast majority of the defence and counterclaim, because if absent those duties, really, they just don't get off the ground, even with the counterclaim. The next allegation of implied terms is that the contract imported regulatory duties by implication. Now that this isn't referred to at all in my learned friend's skeleton argument, but it is in the defence. Just to deal with it in case it's maintained, it's simply wrong as a matter of law. First, I've shown you the exclusion of all implied terms. And that's not to say that the bank isn't obliged to comply with its regulatory duties. Of course, it is. But the question of whether they form part of the contract is quite a separate one. And it's important. And I'll show you the duties in a moment that are relied on, because unless they can be imported into the contract, it's difficult to see how they can be attached to the sorts of rights and obligations that the defendants say they should be attached to. But the point is that regulatory duties form a separate code from the contractual rights and obligations, so they are not routinely implied into contracts unless the contract says so in terms. And that's been looked at again in the EMBD and Advanced Facilities case, and the DIFC Court of Appeal endorsed the statement from Target Rich. And I can show you that at page 1366 of the bundle. And it's paragraph 117. And this is Lord Justice Gross sitting in the DIFC Court of Appeal giving judgment. And he says, fourthly, even assuming in the defendant's favour that the regulatory position is as submitted, the decision in Target Rich does not advance the defendant's case. At 95, in a passage with which we agree, the learned deputy judge said this: whilst the court will give effect to clear expressions of incorporation, the cases demonstrate a consistent recognition that regulatory obligations are distinct from contractual rights, that they may operate in parallel without fusion, and in particular that mere reference in contractual terms to the existence and content of regulatory obligations will not, or at least will not likely, be treated as an incorporation of any specific obligations mentioned, let alone of the rules as a whole. So even mention won't get you your regulations into your contract, and therefore there cannot be any general principle that you just simply incorporate, you freight all of those regulations into the contract as a matter of course. Now, as I say, the duties themselves are still relied on. We say it is unfortunate that the defendants feel able to make allegations of breach of regulatory duty in this case, but the duties themselves that are relied on, you will find in the defence on page 27 of this bundle, paragraph 5. So page 27. Paragraph 5, you will see the 4 duties that are pleaded, which come from the gen rules of the DFSA. Now, I should say that what you're dealing with is a Singapore bank. Now, in part, the relationship was managed from the DIFC branch. So some of the functions of the bank would have been regulated, others would not. You don't need to decide any of that. I just make it clear that we don't accept that these duties applied wholesale to everything that the bank did in this regard. But let's assume that they did. The duties that are relied on are simply, 1, the bank must observe high standards of integrity and fair dealing. 2, must act with due skill, care and diligence. 3, pay due regard to the interests of the customers and communicate information to them in a clear, fair and not misleading way. And 4, and this doesn't appear to be relevant at all, which is about custody, where we have control of or responsible for assets. We have to arrange proper protection for them. But so those duties are pleaded out and their breach is pleaded out in a very broad way. And that we say they can't possibly get the defendants to a breach as a result of the conduct which they assert. Regulatory obligations require banks to perform the services they've agreed to provide in compliance with the obligations. They don't say anything about what services have to be provided. So a bank who has agreed a facility on an uncommitted basis, so there's no commitment to lend, can't be forced to lend. So the regulations take the defence no further. They may exist, but they can't interfere with the bank's agreed and absolute right to value security, for example, or to decide to just withdraw the facilities. So that's what we say about the duties. But there's no implied duties, but for multiple reasons. That there are potentially regulatory duties, but none of them could enhance, could impose a requirement on the bank to provide enhanced services, if I can put it like that, or provide any services. And when Your Honour comes on to look at the breaches which are actually alleged, we say, then it becomes even more clear that there's actually no real defence here. Very unfortunately, one of the allegations is advanced as an allegation of dishonesty. So it's said that some of these things were not honest. We say that's entirely improper, and it should never have been put that way. And in fact, as we'll come on to, Your Honour will see that what's happened is they've simply misunderstood an email. And you can actually see it from the pleading, but when you place that email in context, it's quite clear that it doesn't say what they say it says. So there are, as I set out, 3 different sort of categories of breach that are alleged. The first is that only half of the facility was made available at the outset. I'll show you that briefly. We're still in the defence, but if you were to go forward, please, to page 37 of the bundle. And paragraph 45.1.
Yes.
What's said is it's admitted that by 12th of October 2021, so that's 6 days after the facilities were agreed, the claimant had not made available the 240 million euro short-term advance overdraft facility under the terms of the facility letter. The claimant's failure to do so amounted to a breach of the terms of the facility documents, which obliged the claimant to make available an on-demand short-term advance overdraft facility. So now, what we say about that on the facts, and you don't need to decide this, is that in reality, only partial utilization was permitted because more security was required. And so it comes down ultimately to the sort of margin approach, but that doesn't matter because the bank wasn't under any obligation to make the lending at all. It's all discretionary, so this can't be a breach. In any event, no loss is alleged to flow from this in the defence. And in the skeleton, my learned friend does assert a loss, but that's his own assertion, not one that's supported by any pleading or particulars or indeed evidence. But he says this is paragraph 65 on page 16 of his skeleton. He makes no reference to any particular document when he says this, but he says the claimant failed to make the required limits available on the defence account. And then he says, which resulted in a loss of trading opportunities for the first defendant. So he's saying, as an assertion, that there was a loss of trading opportunities because large facilities weren't made available. But actually, that's not pleaded. But not only is it not pleaded, it's actually inconsistent with his case, because in other parts of his case, he complains that had the margin limits been dealt with properly, and the defendants had known about the proper margin valuation that was going on, they would not have traded so much. They would not have traded in excess of their margin limits. So he's got a pleaded case. That's on page 40.
40 of the bundle?
Of the bundle. Paragraph 52.6. It's the final sentence where his client pleads out their loss flowing from not knowing what the margin limits properly were. Had they known them, so it's the final sentence on page 40 at the top of the first paragraph, which is the end of 52.6. The final sentence, 4 lines up from the bottom. For the avoidance of doubt.
Could you say?
Of course.
Oh, I see. I've got the wrong page. Sorry.
That's all right. It's page 16 of the defence.
Yeah.
40 of the bundle. And then what we're looking at is the bottom section of paragraph 52.6. And it's the final sentence, 4 lines up from the bottom. For the avoidance of doubt, had the claimant properly informed the first defendant of the purported revaluation, the first defendant would not have traded at a level which exceeded the margin limits imposed by the claimant. So on the one hand, you've got that allegation. On the other hand, you've got my learned friend just asserting, as a matter of fact, that had they had 240 million euros from the outset, they would have spent it all and traded, and that they would have made a profit out of it, which is also inconsistent with the conclusion of all of this, which is that they didn't do very well. And also it ignores all of the points about margin limits. It suggests that if the facility of 240 had been made available in principle, the bank would have been happy to lend that much, despite the fact that the first defendant was almost immediately into margin breach from the 31st of December and maintained that breach for 6 weeks thereafter and was only intermittently within margin limits. So there's no coherent case on loss, there's no pleaded case on loss, but there's no breach in any event which could seriously be argued for in this case when it's all discretionary lending. So that's the first kind of category of breaches or breach that was alleged. The next set of breaches is about revaluation. Let me show you, if I may, what is said about revaluation, and it's effectively the same. We're in the same paragraph, but if we start, please, on the previous page, page 39.
Yes.
Paragraph 52.6. You'll see the breach is in breach of the implied terms set out immediately above or the general rules pleaded above, at some stage during or prior to February 2022, the claimant unilaterally revalued the collateral deposited by the first defendant, with the result that the loan to value ratio fell from around 80% to around 30%. So we say that's a defective pleading. We had an exchange at the outset of this hearing about what that might mean. And we say that it's wholly unclear. It looks like what's being alleged is that the value attributed to items of collateral reduced, such that the total value of the collateral was being booked as being worth less money. But that isn't the way it's put in the skeleton. The skeleton says that it's the loan to value percentage that's applied to the valuation. So it's that question of, are we talking about you got 100 shares worth $1 each? It's the $1 valuation is one part of that, or is it the 75% or the 70% or the 30% or whatever it is that the bank applies as a percentage that you can borrow by reference to that valuation? It looks like the pleading is for the former, but the skeleton is for the latter. But in any event, there's no explanation of what collateral was valued. There's no explanation of what the original valuation was, what its revised valuation was, what valuation should be attributed to it. So the pleading, we say, mixes up concepts, it's incoherent, but also it is just it's just a bare plea. And it's all, this breach is all predicated on there being some objective standard or objective requirement on the part of the bank to value collateral in a particular way. And as I've shown you, there's an express absolute discretion, but in any event, no basis on which you could say that it's in any way constrained. For what it's worth, the evidence on this doesn't help us a great deal, and I'll show you that if I may. If we go to page 697. Sorry, when I say the evidence doesn't help you, I mean the evidence from the defendants. I'll show you some documents in a minute, which does help. This is the witness statement of Dr. Khan on behalf of the defendants. It's paragraph 3.23. And then it's about 4 lines down where he deals with this. And he says, even considering the charge was signed, it was intended to secure the facility of 80% LTV. However, the claimant unilaterally reduced the LTV from 80 to 30%, which eventually fell further to nil. This reduction was never notified to the first defendant. This reduction altered the value of any security provided for the facilities. And when the LTV was eventually reduced to nil, it consequently rendered all contractual obligations under security arrangements also null and void. Happily, that at least isn't argued for by the defendants. It seems to be the consequence that Dr. Khan alone ascribes to it. You will see there he refers to a document, DA2/34. That's the only document he refers to. That can be found at page 743. If we just turn that up, you'll see it actually totally contradicts his position. So this is page 743.
Yes.
And it's the email in the middle of the page dated 4th of February 2022. So the facility's been operating for about 2.5 months at this stage. As you'll recall, there's a margin default going on. And you will see there the basis for the margin calculations is being explained. And what you have is a list of securities. And down the right-hand side, you'll see the loan to value attributed to them. And so some of those are traded liquid securities. You can go onto the market and just sell them at Bloomberg rates. So, for example, Amazon.com shares.
Yes.
And so you'll see the loan to value that's being attributed to those is 70%.
So does that mean, Mr. Montague-Smith, that the bank will lend 70% on an amount equal to 70% of the value of the security?
Of that particular security, yes.
Of that particular
Correct.
security.
Correct. It's
Yes.
slightly different with some of the securities, and in particular, if you look down, you'll see reference in red to the Landstone bond.
Yes.
Now that's a slightly different situation, and I'll take you through what happened in relation to that. It gets a nominal loan to value. It does in fact get a loan to value of 30%, but it's given a nominal valuation of 200 million. And so the result is, by this point, there's a 60 million loan available backed against that particular bond.
Yeah.
But that's what you can see from the Nordrock bonds were always given a zero valuation, and I'll show you how that develops. But effectively, what that shows is that there isn't a single flat rate that's being applied by the bank. They are looking at each individual item of collateral. They are giving it a valuation, and they are saying you can borrow a certain proportion of that value, and it's different for each one, because of course it is, because the different items of collateral carry different levels of risk, and if you have an illiquid piece of collateral which you can't shift soon, you're inevitably bearing greater risk.
And
so
are the DEGV and FRGV, are those bonds, are those government bonds of some sort?
Those are tradable liquid bonds. Yeah, government bonds, precisely. So what is said in the skeleton now, and this appears to be the case we have to meet, is paragraph 31. So sorry,
31 of the skeleton.
31 of the skeleton, but just finishing up on this particular document. This document firstly shows that the pleaded allegation that there was some flat rate that was reduced can't be right, at least not in those terms. Secondly, it shows that there was clearly an explanation being provided of what the collateral and what the margin was and how it was calculated. But what is said at paragraph 31 of the skeleton is that the LTV ratio of the first defendant's account was from 80% to 30%, and then eventually was valued at 0. And then says the claimant attributed this sudden reduction in the LTV ratio to the fluctuating market prices of the products. So there's no statement about when this is supposed to happen. It's presented as if the bank accepts that there was a sort of flat reduction from 80 to 30. That's not correct at all. The tradable securities fluctuated in value, and what the bank has said is part of the reason why there was a margin default was because of the fluctuating values of those securities. But there's no acceptance, of course, that there's been some sudden reduction in collateral LTV valuation. What there was an adjustment.
Your point, as I've understood it, Mr. Montague-Smith, is that there was no LTV for the portfolio as a whole.
Correct.
There were different LTVs for each of the securities.
Correct. And there's no suggestion that any of that changed. And I'll show you some of the documents where that did. But I mean, this is all subject to there being any kind of duty in relation to this. So what did happen was that there was a change in the valuation approach to the Landstone bonds. And you can see that by looking at 2 screenshots from the bank system, one from the morning of the 15th of October 2021 and one from the afternoon of the 15th of October 2021. So we're dealing right at the start, right at the outset of the facility here. It was agreed on the 6th, and I'm going to show you screenshots from the 15th, about 10 days later, 9 days later. So if we look at page 889, please, you'll see this.
You're going to have to walk me through that.
Yeah, absolutely. I understand. So this is a screenshot, an internal screenshot from the bank's system, setting out its its margin status report. And what you'll see in the spreadsheet at the bottom is a series of lines identifying the securities that are held by the bank, which are owned by the first defendant. And so as you go through, you can see Microsoft Corporation, for example, is the first one. You can see the quantity of shares, the last price, the market value being applied, and then you'll see sorry, fixed AR is the column you want to look for. That's the fixed value that is being associated, advance ratio, sorry, the fixed advanced ratio. So that's the 70% that's being applied to those particular shares. But what you will see on the final line, again, this is the morning of the 15th of October, 2021. This is referred to in the evidence. It's not dated itself, but the evidence that Mr. Buehler gives is that that's the position. And I can give you the reference to the evidence if you like. It's on page 777, paragraph 25. It explains what this is. But if you look at the final line, you'll see reference to the Landstone bond.
Yes.
And when you go across, you'll see fixed advanced value and fixed AR are at 0. There's no entry there. But then if we go over the page to 890, you'll see that there is a $30 million valuation attributed to the Landstone bond. And the evidence is that what has happened is that on that date, essentially the bond is given a 0 valuation for general purposes, but there is an exception that is entered on the system to permit borrowing up to 30 million against that bond. And an application is then made for a further exception to increase that limit. And you can see on page 877.
Sorry,
877.
Yes.
I've got that wrong. Yeah, it's 876. In fact, is the actual. It's just the previous page, and you'll see this is an internal email from the bank, but you will see the client's request is being transmitted on the 9th of November, and you'll see the request is as follows, 3 lines down, and then it explains line 1, allow a 60 million drawdown against, and that's the Landstone bonds, which works to approximately 30% LTV because they're normally valued at 200 million. And so what happens as a result of that is that the value, the loan to value that is attributed to the Landstone bond goes up from 30 million to 60 million. And you can see that at page 898. Again, I'll have to explain this to you a little bit, I think. This is a credit, the margin report. It starts at 896, and you'll see this one's dated 3rd of January 2022. You get that in the top right of each page. And on 898, you've got the securities. And you can see 1, 2, 3, 4, 5 lines down the Landstone bond. You can see the nominal amount, if you go across there, is 200 million, because that's the amount that was put on it. And then you've got a fixed advance value of 68 million, but a fixed AR of 30%. And so the way the bank deals with it is to say they can have the lower number of 30% of the valuation or the 68, but it comes out at 60. So that's what happens. And that's the 3rd of January. It's the American dating system, 3rd of January 2022. And if you go forward to page 913, you can see it stays like that throughout the life of this facility, because you've got a 31st of May 2022 report there. And you can see Landstone bond, 30% is maintained, and as it had been all through. So the 30% might be a reference to the Landstone bond, but nothing changed in that regard. And it was an exception. And from that report, you can also see that the advance ratio being applied to all these other securities is not 30%. It varies. So Meta, for example, which is the Facebook branding, Alphabet, which is Google, those are getting a 70% advance ratio. It's only really the Landstone bond that comes in at 30%, and that's because it's a specific and discrete issue. And the defendants were clearly told about this. We say, firstly, I've shown you that document from earlier on, from the 4th of February, which demonstrates they were given the explanation of what advance ratio was being applied. This comes up again, though, if we go to page 571. (571) is an email from the 23rd of March, and you can see there, so that's what 12 days after the banks recalled the loan. And if you see that this is a response to a request for various things from the defendant, and at this paragraph 2, you'll see the bank responding to the request, which says, based on available margin, we should be allowed to buy new positions. So the defendant's saying we ought to be able to trade on these accounts because we're not in margin breach. And the answer comes back: the margin availability currently reflected under this account is only due to the advance previously granted by the bank on an exceptional basis against the Landstone bond. Please note that the bank.
Where's the response?
Sorry, it's written immediately into it underneath.
Oh, I see.
Do you see? So what's happened is he's pasted the questions, and then he's written underneath them, and he says, please note the bank retains the discretion to remove this advance at any time, the removal of which will result in a margin call under this account immediately, and that the bank has held back from exercising this discretion thus far solely as a gesture of goodwill, so as to allow you some time to arrange for an orderly exit closure of your account. In any event, given that the account is to be closed, no further purchase request will be processed by the bank. So they've explained it, and in any event, they have an absolute discretion to do it as they see fit. And they can ascribe zero valuation to any piece of collateral if that's what they want to do. And I've shown you the clause in relation to that. And just so you don't think the bank is being in any way uncommercial here, the bank's position has been entirely vindicated in relation to these bonds, because the bonds didn't pay out, as I've said. So the coupons didn't pay, the bonds couldn't be sold. Both the insurer and the issuer have said that they weren't paid for. And that I can show you those pages if you like. They're at page 494. That's an email from the CEO of the issuer, Larmag Group. Third paragraph down, notwithstanding the above, Bank of Singapore is aware that ARJ has not paid for the bonds. Some of the Nordrock bonds have been partially paid. And the insurance broker repeats the message on page 500, 7th of December. So the bank's position is perfectly reasonable in relation to that, but that's irrelevant to the legal situation, which is whether or not they have a complete discretion. So there's just no prospect of establishing any kind of breach in respect of this alleged revaluation, which didn't in fact take place. That's the second allegation of breach. The final allegation of breach, or final cluster of allegations of breach, relates to transfers, if I can put it like that broadly. So what it said is that the bank blocked transfers of the portfolio or part of the portfolio, or the portfolio and the loan, to third parties. So there's pleading of 2 proposed transfers to third parties, EFG Bank and One Swiss. Another one is raised in the skeleton argument. That's the Credit Suisse one. And so I'll go through each of them. But it's just worth being clear what we are talking about here. MARJ Holdings, the first defendant, has deposited securities with the bank, and it's borrowing against them. And sometimes they have to be liquidated to repay the loan, so you can get back within margin that's being imposed. But the bank is the one that stipulates the margin. And so any request to transfer securities out of that portfolio just by themselves is obviously not going to be satisfactory to the bank, because then it's unsecured. So and because every asset that's held by the bank is security for these loans, and we see that from the charge itself. That's on page 328 if you want to look at it. So if any money is owed to the bank, no security can be withdrawn. And again, I've shown you that clause. That's clause 8.17. That's on page 216. So at various times, Marj Holding sought just simply to ask that cash or securities be transferred to somebody else. But it was overdrawn at all times. At all times it owed money to the bank. There's no dispute about that. So it was totally up to the bank about whether to permit it. And that's a necessary consequence of the bank being entitled to just determine whether to lend at all, to determine what margin should be applied, but it's also an express term of the contract, as I've shown you. So clearly there was no obligation on the bank to leave itself unsecured. Now, at other times, the defendants suggested that there would be a comprehensive transfer, not just of the assets, but also of the liabilities to some other party. And that obviously involves repayment of the total loans. Now, the pleaded case deals with the latter sort of request, and the two banks that were proposed in relation to that are EFG and One Swiss. But the bottom line on each of these, and it's not disputed, is that neither ever offered terms to repay the loans. None of them. None of them even suggested that they would do so. That there is no evidence to the contrary. What the defendants say instead is that the bank somehow blocked those transfers from happening at all. Now, with respect, we say that is incoherent. A transfer for these purposes is simply a repayment of the loan and then transfer out of security. The bank could not block repayment of the loan. If someone wants to put money in their account, then it's going to go into their account, but that never happened. It was never attempted. There's some suggestion that the bank should have simply allowed the transfer of the portfolio out first and then expected to receive repayment of the loan later, but that is totally uncommercial and contrary to the terms of the contract, would leave the bank unsecured. So you have these two pleaded cases about how they get to this allegation that the bank tried to block or did block some transfers. EFG, the case pleaded there is the one that sits simply, I mean, well, we say they're both simply false, but the EFG one is the one where they just simply misread the correspondence. So let me show you that if I may. It's on page 40 of the bundle and paragraph 53.1. Now, what's said here is that, firstly, on the 8th of February, the second defendant, on behalf of the first defendant, sent Mr. Gaurav Sahni, who's for the bank, a letter of instruction for assets transfer via letter of undertaking. So that was said to be an instruction to transfer assets out. And then 53.2.1, the claimant refused to comply with the letter of instruction. Rather, by way of an email sent by Mr. Gaurav Sahni on behalf of the claimants on the 11th of February 2022, Mr. Sahni indicated that the claimant's chief risk officer had, quote, refused to hold the sale of securities till portfolio transfer next week. He wants the margin shortfall to be addressed via the sale of securities or a swift confirmation of incoming funds by Monday, failing which we will have to sell securities to cover the shortfall on Monday evening. The portfolio transfer can happen post-regularization of margin shortfalls. And so that is characterized at paragraph 53.3 to start with, as the claimant refusing to transfer the first defendant's portfolio prior to the margin shortfall being cleared, or threatening to sell the portfolio. And that, at paragraph 53.3.2, is said to be not honest. And that is one pleading that we particularly take exception with. So what has happened here is the defendants are simply misreading the correspondence. You can actually see it from the pleading itself. It's not a refusal to make a transfer. What it is saying is, paragraph 53.2.1, the bank refused to hold the sale of securities until portfolio transfer. I'll take you through some of the correspondence, but what is going on here is the first defendant's in margin breach. The first defendant's saying, well, don't worry about the margin breach. We're going to get a portfolio transfer and someone's going to pay you. And so please don't undertake a sale of securities under the charge. And the bank's saying, no, we're not going to hold that sale. We're going to sell some securities, and we're not going to wait until you've managed to get yourself together to get a third party to swoop in and clear it all out. Now, this emerges very clearly, we say, from the correspondence. I've set it out in paragraph.
Just before you do that,
yes, of course.
I just want to read again that paragraph you took me to, 53.2.1.
Correct.
Yes, okay.
So that's the email where they say we refused to transfer any kind of transfer until margin. I mean, it's an incoherent plea, because if
what it's saying, it's saying the bank is not going to stop or not sell securities. It will in effect continue or sell securities unless and until the margin
correct
is fixed.
And we won't hold that off while you arrange this transfer that you're talking about. So that's what they're saying. But it's presented, the plea is that actually what's happening is we're refusing to do any kind of transfer until margin is regularized. But that's an incoherent plea, because the transfer would have regularized margin, because it would have paid off the loan. So it doesn't make any sense at all. And it's not what's said. And this is the foundation for a plea of dishonesty. I mean, it really is pretty disgraceful stuff, frankly. But so, as you say, what the bank is saying is we're not going to sell your stuff. We're not going to sell your securities. Sorry, we are going to sell your securities.
We are going to sell.
Yeah. In fact, the bank doesn't do that until September. So it's slightly saber rattling. It's saying, please just get yourself back into margin. But it's got nothing to do with trying to block a transfer or anything. What I was going to do is just show you, I think, two sections of the correspondence briefly, and we do need to go through this in a little bit of detail. As I say, you don't need to decide any of this, because nobody ever tried to pay off the loans, and that's really what matters. But it is worth looking at it briefly, because there's just no substance to any of this. If we go to page 522. And start here at the bottom, sorry, in the middle.
So what are we looking at here?
We're looking at an email from, you'll see someone at the Bank of Singapore. This is on the 7th of February, and emailing to the first defendant. You can't see that in the heading, but you can see above the response from Haider. Haider, which is Dr. Khan, maybe better Dr. Haider, but in any event, what's being said here is you've been in margin shortfall. So our earlier margin call letter was issued on the 11th of January. We're now on the 7th of February, and MARJ Holdings account has remained in margin shortfall since then. We require funds immediately. So then we go back to the previous email that responds to this from Dr. Khan, the subsequent email. And you can see so the main paragraph at the bottom of that page, we're monitoring the margin deficit situation very closely. It has narrowed after the last trading session on Friday and shall further reduce today. It's just pausing there. This is Dr. Khan, who gives evidence that they were not in breach of margin, that all breaches were remedied. He's accepted there's a margin
So he's
breach.
saying there, is he, that the price of the value of the securities has gone up? The market price has gone up, and therefore the margin is reduced. Is that what he's saying?
Effectively, or it may be the result of the trading on the account, one or the other. But he's saying, it's going to come down, and then you'll see. I'll skip to page 520 if I may. There's a little bit more there, but in the middle of page 520, which is just 2 pages up, you'll see the email from Mr. Sani. To Dr. Khan, third sentence. So it says, "Dear Haider, hope you're doing well." And then it says, "To update, the margin shortfall level has further worsened to 9.1 million today." So it's got worse. And the response comes back from Dr. Khan: "Thanks, we'll regularize the account today." That's the 8th of February. Then we go to the next email above, which starts on page 519. And he talks about the shortfall. This is from Dr. Khan, 9th of February. He talks about the shortfall, but it's the third major paragraph there. He says, therefore, I've attached the instructions for the outward transfer of securities and total outstanding of 190 million as an assurance that in case I'm unable to zero-wise the shortfall within the next 2 days, then the total outstanding shall be taken over by EFG. You will receive formal communication from the bank settlement team during the day, which you may hold for 2 days. So just recall that the defendant's cases that they gave an instruction on the 8th of February, which the bank refused to comply with. It's just totally inconsistent with what's actually going on here. They're saying, we will sort out the margin default. If we don't do it within the next 2 days, we're going to get this transfer sorted out, and the whole thing will be off your books. So if we carry on the story, by the end of the day, on the 9th of February, you'll see the bank emailing saying, dear Dr. Hayder, the margin deficit currently stands at 8.1 million. And then page back up to page 518, Mr. Sani, in the middle of the page, emails Dr. Khan and says, as spoken and agreed, request you to kindly share with us swift confirmation for the funds remitted to the account, or you may also trim down your positions. So there's talk of trying to regularize the margin, and then says, alternatively, we need a confirmation from EFG about payment of the outstanding loan towards portfolio transfer by a letter of undertaking to hold back credit from addressing the margin shortfall. In other words, from selling securities at our end. So there's no suggestion that the bank is blocking this. And then further up the page, you see on the 10th of February, Mr. Sani says, request you to kindly update us on funds transfer / portfolio transfer to EFG. We've also not heard anything yet from EFG on the transfer. And then what happens is a series of promises. So page 517, 11th of February, this is at the bottom of the page. Dear Dr. Hayder, since the margin situation remains unaddressed, Credit will sell 8,825 shares of Amazon today to cover the margin shortfall. And above that, Dr. Khan comes back. No, you will not sell, dear Gaurav. He's saying, look, don't sell. We're going to, and then eventually at the bottom of that paragraph, he says, we will place the sell orders. Once US opens, please refrain from any forced sell. But then 11th of February, we're now at page 516. Dear Dr. Hayder, this is the middle of the page. The current margin shortfall stands at 8.11 million. Your yesterday's orders were as follows, and explains why. Response comes back from Dr. Khan, 11th of February. We've notified EFG via attached email to initiate the transfer process, which we kept on hold earlier. So they've kept it on hold, but they will now proceed. So they will be in touch. So again, that's from Dr. Khan, who says, we gave an instruction on the 8th and the bank blocked it. It's just not true. And then there's only a few more pages of this that I just want to show you because you can see where the story ends with the EFG. Page 555 now.
So 555,
please.
Right.
We're now at the 14th of February, looking at the middle of the page. The bank emails Dr. Khan and others. Dear all, it's past 5 p.m. in Dubai, and we've still not received any swift communication from either EFG Bank or the client. So no one's paid us. So we're going to sell, they say. And then the response comes back from Dr. Khan again. This is on page 554 at the bottom. And it's saying, don't try to manage us. So you're complaining about the bank basically exercising their rights, and says, third line, we will sell open positions you ourselves in today's US trading session if you don't receive the communication from EFG. And then back to 553. So we're now on the 14th of February again, and this is Dr. Khan in the middle of the page again. Dear Gaurav, the market is showing some gains, and says, and tomorrow EFG will start the process of taking over the portfolio, but asks, we've sold some, sorry, 552 now. The response comes back, well, you're still in deficit of 5.5 million. And this is what you have to do. It does look like they finally cleared the deficit on the 15th. So because what happens is he asks for the explanation of the deficit, and then it looks like it gets cleared. But then there's nothing in from EFG at all until we don't hear anything directly from them. But on page 557 now, we see the final word on EFG. It's page 557.
Yes.
Hi Imran, this is from GRIP, who are acting on for Dr. Haider and his entities, including the first defendant. Hi Imran, I spoke to Mr. Juma. Now, thus the follow-on update. Given there was a change in composition of the portfolio constituents, they've had to go and seek revisions on the initial proposal, which had been outlined to EFG and for which the approval had been sought. This was the reason cited by him on the delay on the part of EFG in reaching out to Bank of Singapore to take over the portfolio. So the case is the bank blocked it. The contemporaneous documents show that that is simply false. This is the edifice on which a dishonesty plea is alleged. So the facts are false. You can see that from the documentation. You don't have to accept some assertion from Dr. Khan that it's different. You can just see it from what was happening at the time. But even if the facts could be made out, it wouldn't get them anywhere unless somebody actually made a payment to the bank and the bank still then said, no, we're going to keep your security, which of course is not something that ever happened. So that's EFG. We'll just deal with the other two. One Swiss is the first and Credit Suisse is the second. So the other, the One Swiss allegation, I'll show you how it's pleaded. It's at page 41 of the bundle. And it's at the bottom of the page, paragraph 57.1. We're starting with the preamble to 57. It says the first paragraph, it says, upon receipt of the letter of the 11th of March, that's the letter where we said repay everything. The first defendant began the process of arranging for the first defendant's portfolio held with the claimant to be transferred to One Swiss bank. The transfer of the first defendant's portfolio would, if completed, have resulted in full repayment of any sums then due to the claimant. It's not clear whether by portfolio they include the loans, in other words, the liabilities. So it's not clear if what is being said is that the bank should have allowed the portfolio to go out first, or whether they're saying that there was some proposal to have everything transferred, including the liabilities. If it's the bank should have allowed the portfolio to go out first, that's obviously, we say, both commercially and legally absurd, because it would leave the bank unsecured. 57.1 sets out the particulars. By way of email, dated 23 March 2022, Mr. Manoj Tuteja, on behalf of the claimant, stated that the claimant would not allow transfer out of the portfolio until all amounts owing to the bank have been repaid in full. Pending disclosure, the defendants will also aver that the claimant contacted One Swiss directly without the authority of the defendants and in breach of the terms of the facility agreement documents, and that as a result of the claimant's contact, One Swiss bank subsequently decided not to proceed with the proposed transfer of the first defendant's portfolio loan. So the first allegation actually is that the bank, it appears, should have just let all of the security go and then waited to get paid, which as we say is just nonsense. The second one is that they say, well, pending disclosure, we're going to say this. We're going to say that you maybe reached out to the bank and that maybe that scuppered the deal. They don't say when that happened. They don't say what was said. They don't say who said it. It's speculation at this point, and that's apparent from them saying pending disclosure, we will say. They're inviting an inference, but there's no facts to support the inference. But what is critical here is that they accept one Swiss bank withdrew. They say that in terms. One Swiss bank subsequently decided not to proceed. And that's quite important, because I'm about to take you through the correspondence. And the correspondence shows the defendants saying right up until the 19th of September, 10 days before we liquidated the security, that one Swiss was going to come through. So they were telling us one thing in the correspondence at the time, which they now say was false. When you go through the documents, you will see that there is this sort of familiar story. And again, I won't go through it all. I've given you the references if you'd like to see them. Paragraph 34 of my skeleton argument, where the bank chases on many occasions, asking, well, you've told us that one Swiss might be interested. Give us an update. Give us an update. Give us an update. By this stage, of course, the bank's already given notice to close the accounts. The money's due immediately. The money was due on demand. So one Swiss is being offered as a way to repay the lending. And the responses that keep coming back are, it's coming imminently. It will be in days, few days. So one Swiss will be lined up. And I've given you again the references at paragraph 35 for my skeleton. And the excuses that were given by the defendants was that one Swiss was experiencing, quotes, unexpected procedural delays. And the delays were said to be procedural only. And so I won't take you through all of that, but to give you a sense of the attitude of the bank, and to judge it by reference to this allegation that the bank was blocking this transfer. If you go to page 629, you'll see an email there from June. So a long time into this process, well past March. 629 at the bottom of the page, you get this communication from GRIP on behalf of the first defendant. And it says, Dear Gaurav, so it's an email to the bank. As alternatives to one Swiss, discussions have been initiated with 5 other banks. And the bank's response to that is one of dismay. The bank comes back and says, well, it's very disturbing to see at this late stage that talks are being initiated. You're putting us in a very difficult position. We need to close this issue as we've taken a lot of grace period from credit and are being pushed by them to close this matter. So the idea, again, is that the allegation is that we're blocking it, but we're not. The bank is saying, you're starting again, and we're in June. We've been doing this since March. And we go towards there's a lot more to this in terms of correspondence, which again I won't take you through, but if you want it, all of the correspondence is referred to at paragraphs 34 to 37, the really important stuff, 34 to 37. But I will just show you the end of the story. If we go to page 684, yes. What you've got there at the bottom is an email on the 19th of September to various people, including Mr. Juma and Dr. Khan, and said, following our meetings, kindly update us on the portfolio transfer status to one Swiss. And then over the page, also request you to kindly share the facility letter received from one Swiss as per your commitment given during the said meeting. So they've been told in a meeting that one Swiss is still on board. They've got a facility letter coming. And then above 684, the response comes back, just to update Bank of Singapore that to the best of our knowledge, one Swiss shall be able to send the transfer instructions by tomorrow. This is the 19th of September. That's 10 days before liquidation. The transfers instructions are coming tomorrow. And as if you do go through all that correspondence, you'll see similar statements. It's coming, it's coming, it's coming, it's coming. And that now they admit in their defense, well, actually one Swiss withdrew. So this appears just to have been lies that are being told. You don't need to reach a conclusion on that. But as to the question, did the bank do something to put one Swiss off? there is no supportable argument to that effect. That's one Swiss. The skeleton argument raises one other complaint, and this is raised at paragraph 45. It appears in the evidence, but not in the pleading, but I'll deal with it. And it's an argument in relation to Credit Suisse, but there's nothing in it. What is said in the skeleton argument is that an instance where the claimant hindered the transfer process was in December 2021, when the first defendant requested the account to be transferred to Credit Suisse. For this transfer, the claimant had delayed the procedures to such an extent that a receiving bank had no choice but to abandon the transfer. So firstly, if we go to page 783, we get the document that's being relied on here. And you'll see an email from Credit Suisse saying, "Dear Gaurav, I trust all is well." So it's an email from Credit Suisse to the Bank of Singapore. We've received the instructions from our mutual client to receive the below securities through LOU DVP from their account held with Bank of Singapore. And then says, we understood that we should pay back Bank of Singapore approximately a certain amount. Now, quite what's going on there is unclear, but what it is not is an attempt to transfer the entire account from one to the other. That's the document that my learned friend relies on. It's not the whole portfolio. It's not proposing to pay off the loan. It's saying, please transfer out some securities, and the bank has no obligation to do that. And the bank explains all this subsequently. If you go to page 398, we see it. It's page 398. You're looking at an email from the bank to Dr. Khan. And you'll see there paragraph 4 of that email on 398. With regards to portfolio transfers to CS, Credit Suisse, as communicated earlier, this has been held due to credit approvals, which have been pending due to coupon payment issue. We cannot commit on this till credit conditions are met for their due approval. So the coupon that was due on the 31st of December hasn't arrived, and they're saying we're not going to let securities go from your portfolio because we're not happy that we're covered. And they're entitled, that's at their discretion to do that. And unless they can get our agreement, everything in that account is locked in that account to meet the loan. So it's not the sort of transfer that's being alleged by my learned friend in his skeleton argument, which would involve the loan being sent off. That's never in contemplation. It's just a request to transfer things out. So that's it on transfers. There's nothing in it. There is one other alleged breach in the skeleton argument. It's not pleaded. What is said is that the bank breached confidentiality obligations in relation to the Landstone bonds. How did it do that? By contacting the issuer of the bonds. So these were the bonds that were held as security for the loan, and it said, well, you shouldn't have gone to the issuer and asked why it wasn't paying a coupon, asked why you couldn't shift it in a sale. I mean, it is absurd. It's not a pleaded case, but it's just a bizarre allegation. What is the confidential information that we're being said to have released? That we hold it as security? The idea that you're not entitled to go to the bond issuer to talk about a bond, to ask about a bond, which you're holding as security, is just I've never heard a suggestion of that sort before. And it doesn't make any sense, but no source of this confidentiality is identified. In fact, the information is coming from the bond issuer. So perhaps they have an argument against the issuer that they shouldn't have revealed this information. But the information given is that there's no value in the bond because they haven't paid for it. So the idea that some breach there is absurd. There's no allegation of loss that flows from this. What's the loss? There isn't any. So that's the only other defence. So as you go through each of the defences, none of them work. The other point to make in relation to this is none of these would amount to a defence anyway. They would only ever amount to a counterclaim, because there's a no set-off clause in the contract. So that's at page 210.
Just bear with me, I want to look at that. So what document is this in?
This is in the services agreement.
Service agreement.
And it's clause A9. And yes, you'll see it actually appears over the page on page 211. A9 is quite a long clause again, but on page 211, it says, unless otherwise agreed, all payments to the bank shall be made without set-off or counterclaim, and free and clear of any deductions and so forth. It's a standard clause in most facility agreements. Counterclaims don't amount to defences. So at best, if there was anything in any of this, you would be able to give judgment for the bank, and then the defendants would be left running their counterclaim, and presumably would be ordered to give security for the cost of doing so, frankly. But there we are. So, but obviously our primary position is that there's nothing in it. Now,
well, just on that point.
Yes.
The relief you seek is immediate judgment.
Correct.
And if granted, that will leave the counterclaim on foot anyway, won't it?
Well, we're seeking immediate judgment on the claim and the counterclaim.
And on the counterclaim.
Yeah. We'd like the whole thing brought to an end for obvious reasons. But I think depending on how you approach the issues, you could just say, well, there's no defence because of that clause. And leave it at that. But we would invite you to go into in a bit more detail each of the issues that I've been raising, because each of those would be determined finally as a result of your judgment on this, and therefore they couldn't come back later and say, well, we've got a counterclaim which contradicts that. So today would be the end of all of it, if you agree with me on points like duties, points like breach, and that seems to us to be the most sensible way. In terms of, I've got a little bit more. I need to deal with quantum and I need to deal with the guarantee.
Yes.
In terms of timing, I'm not doing too badly. I think I said 2 hours and possibly 15. So I'll try and wrap it up in 10 minutes if I can. Thank you very much.
I was told, I don't know, I was told 6 hours, so we're in credit in that.
We are.
To that extent.
Very good. Yes. So some of the judges here are rather more robust when it comes to time estimates and all the rest. So very glad for a little bit of extra grace. So thank you. But the dealing, so I've dealt with the claim against MARJ Holding, which is the first defendant. The quantum in relation to that, just so you understand what the points were that were raised. The only points that were raised were points about the realization of security. So they accept, as I understand it, the debt. There's no allegation that security was realized in a way that breached any kind of duty. There's no actual allegation of that. What was said was, we can't tell you what our position is on the debt until we know how you realized the security. They've had all that information. They served a request for particulars, request for further information, interrogatories, as they're sometimes called, and we gave them all of that. We gave them all of the documentation. There's further evidence that's come in. What has happened is that the liquid securities have been sold. The illiquid securities could not be sold.
That's the
in
bonds.
Terms of the bonds.
The Landstone and the Nordrock.
Correct. So those we still have. And the because they raised queries about them, what we've done is we've produced Bloomberg ranges for the day for each of the securities that were sold, and if anybody wanted to check, they would see that each of those securities was sold within those ranges. So there's not an awful lot that could be done there. There were some liquid bonds that were sold over the counter, and you have a little bit of evidence in relation to that, but there's no allegation that those were undersold. You just load them onto the system, take the highest bid. What is now said in my learned friend's skeleton argument is that there's something to be made of the fact that the bank couldn't sell the illiquid bonds, the Landstone and the Nordrock. What he says is what they should have sold them. They failed to do so, and therefore, well, it's quite hard to see what the therefore is. The short point here is there's no obligation to sell the security. There's a right to sell the security. There's no contractual obligation to do so. And even if there was a contractual obligation, it would never be, you must sell them. What if you can't? We can't. We've put them up for sale. They didn't sell. And if they pay us our $55 million, then no doubt they can have them back if they're worth anything and they want them. I mean, it's not terribly surprising that we couldn't sell bonds that the issuer has subsequently said are unpaid. So there's obviously, I mean, even if that's wrong, there's a dispute in relation to them. So we can't get any money out of them. But the bottom line is that we sold what we could, credited it, and that's where you get your 55 million from once you load on the interest. So there's no real issues there as far as we can see. So that's the case against the first defendant. As to the second defendant,
well, just before you leave
sorry, yes, of course.
that quantum, where do I see that figure?
So the most recent, there's various statements of accounts, but the most recent one you will find at page 1562. The one that was used to support the application was an earlier one, because the most recent one, for obvious reasons, wasn't available. And the earlier one is dated 31st of May 2023, which was, I think, around the date of the application. And you may notice me trying desperately to find out where it is, but someone's going to
sorry, did you say 1562?
1562 is the final
I only
page.
have 1546 in the bundle.
Ah, it should be on the bundle.
Ah,
It comes right at the end of the bundle.
go down, try.
It may be just if you refresh the page.
I will try again.
Thank you.
No, my bundle finishes at 1546.
Ah, are you on? Your Honor, are you using the online bundle?
Well, I downloaded it. Has something been added to it?
It may have come later. So you may. So if you're finishing at 1546, you may have missed out on some things like statements of costs and the like.
I have, yes, I've seen the statements of costs. But
I think the defendants probably came afterwards. So the defendants is on 1547. You've got a chronology at 1550, and then the latest updated interest calculation at 1557. But it may only be available to you online.
Yes, I'll just look on another laptop.
Justice Lemiere, if I may,
Yes.
I'm downloading it right now, and I can send you a link of the updated bundle.
Thank you. Yes, thank you, Said.
Apologies for the inconvenience.
I suspect I'm the one who should be apologising, but it's I mean, obviously it's it's an interest calculation. What you've got in the bundle already, starting at page 317, and I've already shown you this, is the one we rotated our bundles for, which is the portfolio statement as at 31st May 2023. So all that has changed since then is the introduction of further monthly interest payments that were due. So it's really just the interest calculation.
Right.
And it's a matter of maths and nothing else, and it's an automatically generated system report which just identifies the total interest that's accrued since then. All
right, I've got the online 1562. Yes,
very good. Thank you. So that's the 55,193,715.33.
Yep, got it.
So that's the sum that we seek. There would be further interest that would accrue after that post judgment, and if you want an absolutely precise, sometimes what happens in these sorts of cases is the judge will say, and indeed in advanced facility case, the judge said, please just give us a calculation up to a certain date in the future, and I'll issue my judgment.
Yes.
We can provide that if needs be.
Okay.
So that's the claim against the first defendant. As against the second defendant, the question is simply, is this guarantee valid? You've seen the point about the witness. You've got a witness statement from the witness, page 304. No, you haven't. Sorry, you do, but it's not at page 304. So sorry. You've got a witness statement from him somewhere else. I've rotated my bundle upside down now, so I just have to pause for a moment to apologise. Yeah, so Mr. Sani's witness statement starts at page 687. And it's a bit faint, I'm afraid, but the relevant bits are paragraphs 3 and 4. And he confirms that he attended and witnessed. My learned friend's response to this evidence is that it is, as he puts it, circumstantial. It's not. It's direct first-hand witness evidence from an individual, and there's no reason to deny it. Indeed, nobody does deny it. Dr. Khan has given evidence, but he studiously does not say Mr. Sani wasn't in the room. Mr. Juma does not provide a witness statement at all. So you've got evidence from one person. So the 2 points that are made about him are, 1, he wasn't independent, and 2, he didn't apply his signature until later. And this is where I can show you the English Act, which does which could affect the validity of a witness signature in England, and that's at page 1400 of the bundle. So this is an extract from the Law of Property Act, miscellaneous provisions, 1989. If you just to explain it, if we start at page 1399, you can see the opening passages of the law itself, and what it does is that section 11A.
Sorry, could you just say that again? I had things happening on my.
That's quite all right. Yeah, of course. That's the part of the problem of digital hearings, I think. You get some notifications popping up left, right, and centre.
That's right.
So this is the miscellaneous provisions, the Law of Property Miscellaneous Provisions Act 1989. It's an English statute introduced in, I think, 1989. And section 1, you'll see, is entitled Deeds and Their Execution. And what it does is it sweeps away the common law of certain aspects of the common law of deeds. So it says any rule of law which restricts the substances on which a deed may be written, requires a seal, requires authority, and so forth, is abolished. So it sweeps away the common law, and then what it introduces, in particular at subsection 3, is the requirement that an instrument is validly executed as a deed by an individual if and only if A, it is signed by him in the presence of a witness who attests the signature, and at his direction if there are 2 witnesses, and B, it's delivered as a deed. So the requirement under English law is simply that it's signed by him in the presence of a witness who attests the signature. There's no requirement as to who that witness can be. There's no stipulation that it be a notary, for example. There's no requirement about when or where they attest, that is, that they sign the document. So even in English law, this isn't a problem, but this is an English law, and we say there's no, we haven't found an equivalent statute in Singapore. No one's been able to show us that it exists, and it, from our researchers, doesn't exist. You don't have to take that from me though, because it would be for my learned friend to produce the statute from Singapore and say to you, there is this distinct problem in Singapore, and this particular signatory infringes that rule. But he doesn't do that because it doesn't exist. So that's the first point. it does work as a deed, and the problems with it being a deed that are alleged don't arise. But then the second point is, well, all right, assume it's not a deed, it's still a contract. There's nothing wrong with it operating as a contract. And my learned friend doesn't deal with this at all in his submissions. In the defense, what is said is that there is a problem of past consideration. Why is there a problem of past consideration? Because they say, well, the guarantee was provided on the 6th of October, but the facility letter is dated the 5th of October. So it's past. Now, there are any number of problems with that. The first of it, so of course, a contract needs consideration under Singapore law just as it does under English law. It doesn't, by the way, under DIFC law. There's no requirement for consideration under DIFC law. DIFC law is based on the unidroit principle.
I look forward to that.
Yeah, look forward to that. Yeah. But under Singapore law, we'd accept you need consideration for a contract. Right. But the facility letter wasn't a contract. The facility letter was an offer. It's not agreed until it's agreed. And until it's agreed, it's not withdrawn. And everything was agreed on the 6th of October. So that's the first problem. The second problem is that even once the facility letter is agreed, there's no obligation to lend. And so the guarantee is consideration for the consideration for the guarantee is the anticipation of future lending and the future lending. So that if anything, the consideration comes later. And then the third is that it was a condition precedent to any lending that the guarantee be provided. That's in the CTF agreement, page 279. And it's clause G3. And it says any lending is subject to, and amongst them, the relevant security documents, of which this is one. But even if there was a sort of technical potential problem with past consideration, past consideration can be sufficient, and courts strive to find consideration in situations like this. And I've summarised so I've set out the relevant authorities in my skeleton argument on this, paragraph 127 is probably the easiest place to look at it is there, where Lady Justice Andrews, sorry, it's not Mrs. Justice Andrews anymore, Lady Justice Andrews' book, The Law of Guarantees, summarises the position. The court's entitled to look at the substance of the matter, and it may determine in an appropriate case that the underlying transaction for which the guarantee is given and the guarantee itself are really part of a single transaction or a series of interrelated and mutually supportive linked transactions. So that's really the test. Is it part of a single or linked set of transactions? It obviously is. And I've given you a reference to a case called Classic Maritime, where Miss Justice Cook, who obviously also sits in this court, looked at this and considered a similar argument. In that case, there was a 13-day gap, not a one-day gap, and he described it as totally devoid of commercial sense and happily wrong. That's the Classic Maritime case. But if you want to, you can look at the look at the passages there. I'll give you the reference if you need it. It's page 993 and 994. Paragraphs 37 and 43. So that's the second problem with the argument that this guarantee doesn't operate. And the third problem is that there would be an estoppel anyway. And that's applying the Court of Appeal approach in England in Shah and Shah. If you present a document as a guarantee, as valid, and it's relied on to that effect for lending, you can't turn around later and say, aha, there was a problem with the witnessing. And that's the Shah and Shah Court of Appeal decision. So on any view, there really is no response to this from either defendant, and that's presumably why they offered to pay £3 million a month to repay these loans. They haven't done that either, and now we're 18 months past the demand for repayment and not seen a cent. So we say it is time to bring this to a close and ask your Honour to grant us judgment on that. Unless Your Honour has any questions for me, those were my. Oh, I did have one. You asked me what is the authority that deals with foreign law, It's
Yeah.
not in the bundle. We can supply it, of course, if necessary, but it's a case called Fidel and Felicia. Felicia is spelled Felicia. And it's referred to at paragraph 103 of the EMBD and Advanced Facilities case, which you have in the bundle.
Right.
And
Thank you.
the relevant passage, is there. It's page 1364 of the bundle, where they repeat that passage. Yeah, I do apologize for not being able to remember the name. It was an arbitration case, so I remember the names of the parties, but then they become anonymized with this in this distinctive way of the DIFC Court of Appeal. That's how it is. So unless there's any questions that Your Honour has at this stage, those are my submissions for now.
What about costs? What is the practice here? Should I deliver a decision and then deal with costs, or?
So it depends. If Your Honour has a decision to make, one option would be to make a decision today with reasons to follow, and then we can talk about costs as a result of that. Otherwise, what normally happens is that in a judgment that's reserved, the court will hand down, yes. and sometimes they will say, give us cost submissions subsequently. More often they will say, our initial view is this. Anyone who wants to say we should do something different should deal with that, or should make submissions in a certain period of time.
It's the quantum of costs which is novel to me.
So in relation to quantum of costs, the rule, which is more observed by not observing it, is that for a one-day hearing, the cost of the hearing would normally be assessed summarily. So you would go through the schedule and say, I give you X. In this case, very often, though, what the court does is it just says, I'll give you a certain amount on account of those costs, and then the rest can go off for assessment. And the starting point for that is usually around half of what is claimed. And there's a practice direction that says that. In the current case, our cost schedule is for the entirety of the action, the sense of which being that, yes, we have incurred distinct costs for this application, but if we're successful on the application, we should in principle be entitled to our costs of the whole thing. And therefore, the most efficient way to do it would be just to say, costs in principle are paid by the defendants, and then a payment on account of the entirety of the costs of X. I think there might be an argument about the basis on which you award costs, that you may be familiar with the standard basis and the indemnity basis. And I think we would, in this case, be asking for indemnity costs for a number of reasons. It doesn't affect the sort of final analysis that much, because it's always what our reasonable costs were, but it affects how the court assesses that and approaches that. So there might be one or two arguments to be had at a later stage.
All right. Well, thank you for that.
Thank you very much.
What we might do then, it's now 23 minutes past the hour in our various locations. If we might come back at 45 minutes past the hour, so we'll take a break of about 22 minutes and come back at about 45 minutes past the hour, wherever we are.
Yeah, very good. Thank you very much.
Right, thank you.
Now I'm having a problem with my
I can see and hear you, Mr. Montague-Smith. Oh,
very good. Well, I cannot see myself, but that is of no consequence.
All right. Well, I think Mr. Whitehead, if you're ready, I'm ready.
Thank you, Your Honour. So good afternoon, Your Honour. As you're aware, I act on behalf of the defendants in this case, and the defendant's position is that the DIFC court should dismiss the claimant's immediate judgment application request and award the defendant's costs in having to defend itself in these proceedings. The defendant's position is that, despite what the claimant's assertions are, that this is not just a simple, straightforward debt claim. Instead, Your Honour, on behalf of the defendants, I would like to make submissions on what we see as 7 key points which arise on this application and that need to correctly and properly be addressed. May I, Your Honour, please identify these issues, and then I will go on to develop my submissions on each one of them.
Yes, please.
So the first submission, thank you. So the first submission, Your Honour, is that on the facts, we say that the claimant unilaterally reduced the loan to value ratio on certain bonds, particularly the Landstone bonds, from 80 to 30% without informing the defendants, and that this reduction did in fact result in a deficit on the first defendant's portfolio, which triggered a margin call. I have discussed this in detail at G1, paragraph G1 of my skeleton argument, and like I said, I will go on to elaborate on that shortly. The second argument, Your Honour, is that the defence position is that the claimant unreasonably impeded the efforts of the first defendant to obtain refinancing of the portfolio for the purposes of clearing the outstanding liabilities. Third, the claimant incorrectly confirmed the status of the Landstone and Nordrock bonds in its immediate judgment application. And in doing so, there's this issue, which I know my learned friend has addressed, which we will go on to address in our submissions, of this customer confidentiality point in approaching the issuer of the bonds without informing or obtaining the consent of the first defendant. The fourth point I'd like to then discuss is that the claimant incorrectly confirmed in its immediate judgment application that the defendant failed to meet the margin calls, when on many occasions it actually did meet the margin calls which were requested, albeit further margin call requests were made. And then the fifth point I'd like to make, Your Honour, is that the claimant failed to provide the initial trading facilities limit, and this in fact has brought the DIC courts and brought before the DIC courts, and owing to this, the first defendant had lost opportunities to profit from trades, which again is in breach of the facility agreement. The sixth argument I'd like to make is that the guarantee purportedly signed by the second defendant was not in fact witnessed in the correct manner, and therefore fails as a deed. And then the final point which I'd like to address, Your Honour, on is the counterclaim and the losses which are owed to the claimant by the claimant's to the defendants by the claimant's conduct in terms of arbitrarily reducing the LTV. Your Honour, before I go on to these arguments, I'd just like to make a very small housekeeping point. Perhaps I should have raised this before Mr. Montague-Smith raised his submissions, but there has been some protracted correspondence between the parties in terms of the procedural elements which we arise in today. Now, there's, as I'm sure you're aware, there's been significant evidence submitted at the 11th hour on this case, and there's basically in one exhibit by Mr. Boris Herbscher in his second witness statement, which is 7 pages. In that exhibit, there's 142 pages of evidence which has been presented to the DIFC court not less than a week before this hearing. Now, obviously, we are in this hearing today, but the key point here, Your Honour, is that there's a lot of points and evidence in this submission which does require scrutiny, and it does require time and to review that. And I will go on to explain that in my submissions. But there's a lot of technical banking documents, as Mr. Montague-Smith has in fact gone through some of those with us. But there's a lot of other documents which do require scrutiny. So there is a point of contention here, which is why the defendants tried to push this hearing back slightly so that we could take instructions on that. But obviously that fell on deaf ears, unfortunately. Now, what is quite important is this internal.
Well, just a minute, please. There's been you didn't apply at the outset to adjourn the matter or not to proceed. I'm not sure what it is you're now either applying for, or what your application is, or what you're saying the consequences should be. I don't mean to be disrespectful in saying that sometimes you get in effect a whinge from counsel, but what I really want to know, is there an application? Is there something that you want to do? Is there something you want the court to do, or where does it lead?
Look, I mean, we initially raised this with the claimants before, and there was protracted correspondence between us in terms of informing the court about this. Now, unfortunately, an agreement couldn't be reached, and it's essentially left with us with a bit of a very rushed hearing today, given this huge amount of additional evidence. Now, again, we would it would make sense in terms of proper procedure to allow the parties time to consider the relevant documents and make sure that they're aware of what that evidence is, because there's a lot of points. I mean, I will raise a lot of these in my submissions today, so I propose I go ahead and give you my submissions on all these various points, but I just need to make a line in the sand that this was a problem for us as the defendants.
But are you asking for me to do something? Are you asking for leave to do something, or what exactly is the point of that submission?
Well, I think we are where we are, and you know, we've sort of rolled our sleeves up and got on with it, and we will get on with it. You know, we're aware of the court's time and we're aware of cost. You know, we're here today, and obviously Mr. Montague-Smith presented his submissions. So I will carry on. I'll proceed. It's not an application, but I think it's a very important point a procedural point, because it obviously does put the defendants on the back foot somewhat, especially in immediate.
Mr. Whitehead, I want to make sure that you are not that there is no procedural unfairness visited upon you. We began the hearing. There was no application for an adjournment. If there was some further application to be made by you for leave to file some further evidence or submission, then I would have to entertain that. But what I don't want to happen is for you to, in effect, say that you have not had a proper opportunity, but not to make any application that's directed to that.
Yeah, no, I understand, Your Honour. Look, we just to be absolutely crystal clear, so we're not making an application on that at this stage.
So you're not applying for leave to put on a further witness statement or any further submission?
No.
All right.
Okay, fine. So I'll carry on with my submission, Your Honour. So so I appreciate that my learned friend has addressed you on the ingredients required for a party to claim an immediate judgment and to be granted immediate judgment. And I need obviously not remind you, Honour, of the very high burden and hurdles which need to be satisfied. I think quite helpfully, my learned friend has referred to the case of Emirates NBD Bank, and in particular the points in that case which need to be considered. Now, if I can just go through some of these points, I think it is important just to highlight a few of these points. So in the case, paragraph 18, again, this is a Court of Appeal case. It does confirm that the court must consider whether the claimant has a realistic as opposed to a fanciful prospect of success. Obviously, Swan versus Hillman, as we all know. It then says, which is crucial, in reaching the conclusion, the court must not conduct a mini trial. And more importantly still, it says that there is no real substance in factual assertions made, particularly if contradicted by contemporaneous documents, Your Honour. So here, obviously, it's very important that there's no factual points which muddy the water, so to speak, to not grant that. It goes on to say that the evidence that can be reasonably expected to be available at trial can, and although a case may turn out at trial not to be really complicated, which I think what Mr. Montague-Smith is alleging here, that being straightforward debt recovery claim. It does not follow that
just a minute, please. Just a minute, please, Mr. Whitehead. I hope it was just a momentary glimpse, but your speaking froze for a moment. Could I wind you back to when you said you were talking about it being a complicated case, and Mr. Montague-Smith said, and then I think I lost a few words.
Yeah, no, of course. Yes, so my learned friend explained that this, and I think I quote him to say, is not a straightforward, it's a straightforward debt recovery claim. So what our position is on that is that essentially what the judgment says is that although a case may turn out at trial not to be really complicated, it does not follow that it should not be decided without the fuller investigation into the facts at trial than is possible or permissible on summary judgment. So obviously from the defendant's point of view, the standpoint is very much that this is and does require further investigation, which I'll go on to explain. So in terms of the key points which I'd like to go through, the first point, as I've said, of the 7 points which are the arguments I'd like to raise, is in respect to the claimants arbitrarily and unilaterally re-evaluating the loan-to-value ratio of the Landstone bond.
So if I can stop you for a minute,
yeah.
So I understand the position to be, in essence, I oversimplify it perhaps, but Mr. Montague-Smith says that the loan was repayable on demand. Demand was made, payment has not been made, there is a debt. Is your answer that you don't deny those matters, but you put forward these 7 points as a defence?
Correct, Your Honour. I don't think it's in dispute that obviously there is a debt amount. However, there's various complicating factors which arise, which result in further and more fuller investigations required.
All right.
So, Your Honour, the claimants have said that it did not reevaluate the LTV, but that the margin calls were triggered because of fluctuations in market prices of the collateral. If I can take you to page 97 of the bundle.
Yes.
Yeah. So here, in paragraph 17 of the witness statement.
And what document is this, Mr. Whitehead?
So this is the witness statement of Mr. Brooks on behalf of the
Mr. Brooks.
claimant.
Yes.
Yeah. So paragraph 17, it basically says is the defence alleged that the claimant carried out a unilateral reevaluation of the collateral deposited by the first defendant at some stage during or prior to January to February 2022, which forced a purported default situation upon the first defendant. No such reevaluation took place. The account went into margin shortfall and margin call as a result of fluctuating margin prices of the collateral. I think this is the key point. The defence have no real prospect of establishing that the claimant caused the margin account to go into shortfall. However, Your Honour, this argument is seemingly changed now, as the claimants have said that no value was attributed to the Landstone bond for the purposes of calculating the collateral position to determine if the account was in margin surplus. And if I can take Your Honour to page 777, and at paragraph 23, it reads, I refer to a margin status overview.
Now what document is this?
So this is the second witness statement of Mr. Boris Herbisher. Yeah, Mr. Boris. Yeah. So on behalf of the bank. Yeah.
Yes.
So this is paragraph 23, and it reads, I refer to a margin status overview from 23rd of September 2021, which shows a Landstone bond with no standard advance ratio. This document was attached to the credit application. The effect of this was that no value was attributed to the Landstone bond for the purposes of calculating the collateral position to determine if the account was in margin surplus, margin call deficit, or margin call. So there's a definite change in stance there, and the defendant's position is that if this was the case, then why did Mr. Satney send us a table in respect of the loan to value on the 4th of February 2023? Yeah, and also, Your Honour, the claimant has also filed a portfolio statement, which I think my learned friend referred you to, which is dated 23rd of September 2021, which purportedly shows the standard advance ratio, not the LTV, was at 0%. And I can take you to that. I think you've already been taken to that, but I can take you to that again if you like. Yes, please. So that's on page, that's 866 of the bundle.
Yes.
Yeah. Sorry, Your Honour, I do apologise. We're having some issues with the bundle. Sometimes takes some time to load when we do a page. So if we're slightly delayed, just to let you know, that's why. Well, yeah, you can see here,
Mr. Whitehead. Mr. Whitehead, just to be clear, I would rather go slowly, but ensure that you have every opportunity.
Thank you. I appreciate that. Thank you, Your Honour. So here we can see a table of securities, and it's got the fixed AR as being 0.
Yes.
Okay. So I think to get to the conclusion of this point, Your Honour, is what we're trying to say is that this does raise further issues, which
what is the issue that it raises?
Well, we say there's a change in position, and it's unclear what the actual correct position is in terms of the in the LTV and the percentages. So we would say that this requires an expert, be it a banking expert or a quantum expert, to actually forensically go through and make sure that, you know, things are as is. And also, we would say that it requires further production as well, because there's certain documents which have been produced, which I'll go on to explain, especially internal correspondence, where there's likely other correspondences around those correspondences. Like there's certain selective correspondence which has been cherry-picked by the claimant as part of its case, which is understandable. But at the same time, from a fairness and a point of view, the defendant would need the whole papers which surround that, so that we have a full and more proper view of the case.
Well, can I ask you to go back a step and lead me through this rather slowly? What is it that you say an investigation might or will reveal? That is it some breach of the agreement by the bank, or what is it that the investigation you speak of will reveal?
I think one of the points which I will come on to address in detail, but one of the points my learned friend said is this dishonesty point, and that just to be crystal clear on that, in the pleading it's an or, so it's not, although it does use the word dishonest, and it also uses or good faith. So it's an or provision. It's not and, it's or. So the point here is, what we're trying to establish is, has there been good faith? And I want to stress that word, because especially in this jurisdiction, it's very, very important, good faith, in terms of contractual law. And it's one of the foundations and principles of law. So that's what I'm sort of trying to develop, Your Honour, is, has there been good faith on the part of the claimants?
So are you saying that they exercised some power with a lack of good faith, or there is something they did which was not in good faith, and if so, what?
That's what I, if I may, Your Honour, I'd just like
Yes.
to just develop my
All right,
submission. If I
I'll
may.
let you go for a while.
Thank you. Appreciate that. So yeah, as I've said, I mean, the claimants have introduced some new facts and documents relating to this LTV reduction, and that's been introduced very late, you know, last Friday. So that was, we've gone through and had to go through that in a very short amount of time and look at that. If I can refer you to page 777 of the bundle.
Yes.
Yeah.
So this is again is Mr. What is his name? Boris. What is it?
Hubisher. Is it Hubisher?
Hubisher.
Hubisher. Sorry, Hubisher.
Hubisher.
Excuse my
Hubisher.
pronunciation, though.
No, well, I was looking for your help on
it. So here we can see the claimant has alleged that there's no value which is been attributed to the Landstone bond for the purposes of determining whether the account was in surplus or deficit. Oh, sorry, or in deficit, sorry, which again questions how the claimant did actually determine the value of the collateral, which led to the margin call. So again, this is another point that has not been pleaded, and the defence have not been given a chance to rebut this new evidence. So the claimants have also referred to an exception granted to the first defendant in relation to the Landstone bond, which is to allow reinvestment into quote mega cap liquid securities and other eligible instruments. So again, if we can look at page 777, it reads, on the 15th of October 2021, the claimant granted an exception against the Landstone bond to the first defendant's account to allow the client to start reinvesting into the mega cap liquid securities and other eligible instruments. The exception was 30 million and was set up on 15th of October 2021, valid until 1st of October 2021. The request and credit approval emails are at a reference, and at that time there was no rollover. Okay. So again, as we said, the claimant has introduced this evidence, and there's several emails which have internal correspondence which the defendants didn't have any knowledge of, and we feel it's proper that the claimant, so the defendants have time to dissect and go through that and also to look at correspondence and documents and evidence which relate to that, because there's a lot of points in that which are important, which again, if you indulge me, I will go on to explain. So here, if I can just refer us to 867 of the bundle.
Yes.
So here, this correspondence demonstrates what sort of risk reward scenario or sort of benefit analysis would be focused on in this sort of relationship, because it's a very important email, this, because it actually focuses on whether they should grant the claimant further time. They look at multiple mitigation factors, and that's it, page 868 of the bundle. So if you just go down one page from 867 to 868, and in the final paragraph, it says, and I'll quote, having heard the business and balancing the risk versus long-term franchise value of the MARJ relationship, I'm okay to recommend approval basis as of the above. Separately, I had a word with HOS DXB on banker consequence of wrong commitment made. Now, again, I will come on to this shortly, but that's clear that there's an obvious link between Bank of Singapore and the Dubai branch, and that the DFSA regulations will come into play. So they're clearly thinking, hang on a minute, if we do something wrong here, we've got these banker consequences of wrong commitments made in Dubai. So that just goes to the point, Your Honour, that clearly, although my learned friend has
So
said
what is the reference? What does it mean, banker consequence of wrong commitment made? Well, what is the commitment being referred to, and what is the banker consequence?
Right. Well, this is the thing, Your Honour. It's not clear. That's why I think we would need to find and elaborate more on that, because it's just not clear from the correspondence what that is.
Yeah, I mean, you know this a lot better than I do, obviously.
Yeah.
But it's not immediately obvious to me that it's got anything to do with the regulatory regime. It might do, but it might simply be saying a wrong commitment might be making some reference to allowing some advances where they shouldn't have done, and the banker consequence will be that they're going to be out of money.
Perhaps it is open to interpretation. The way we would interpret that from this jurisdiction, Your Honour, is the fact that there has been a lot of DFSA related investigations and matters relating to various things. So you're quite right. It is open to interpretation, but the way we would interpret that is that they're clearly mindful of risks, as any bank is, and that's the way we perceive.
But risks of what? Risks of just losing their money, or I thought you were either saying or getting at that it might be a risk coming from some breach of regulation or some improper conduct on their part, and I don't know what context or what in this email or surrounding emails can lead me to that interpretation.
Well, I think that I think that is in isolation, that point. So that's where we would like to see if there's any correspondence surrounding that to see if we can develop that, because there's not an awful lot else other than that point in isolation. Yeah.
All right.
So sorry, I do apologize. The screen keeps freezing. I don't know if it's doing the same at your end, but I'll proceed. Yeah.
As long as you're able to, I'll let you know if I have difficulty either seeing or hearing you. But if you're able to continue, do so. Yeah.
Okay. Thank you. So obviously, as I've mentioned, there is reference to this temporary exception. As I've mentioned, the defendants have not had any access to this internal communication and did not receive this communication because they weren't in copy as far as our instructions are concerned, and they did not even apply for an exception and did not sign any application for it. So the defence did not receive this communication from the bank. So it's all sort of new evidence, and it obviously has serious financial ramifications for the defendants in such circumstances. As we've explained in the emails, it's apparent that there were valid reasons for the defendant's request. So as we've seen, there's various points in terms of the risk mitigation profile, which explains why Bank of Singapore, the bank, would grant them such a request. And obviously the defendant's personal guarantee and business reputation would be impacted should they renege on the commitments. So again, it's clear that a solution was presented, because it reads at page 868 that the client can grow into a billion plus AUM relationship, including financial assets, lending, and UL. And then it goes on to read in the final paragraph that I'm okay to recommend approval basis of all of the above. Yeah. So it's clear that there's that commitment there. What we see, obviously, again, just by way of good conduct, it mentions it uses a H, but it's likely the H is next to the B on the keyboard. So it clearly we say it will clearly be DXB, just for good conduct. So yeah, so the point here we're trying to make, Your Honour, is that the internal correspondence, in our view, clearly shows that the claimant made a request to raise the overall LTV on the reinvestment from 70 to 80% through an additional advance value. And I can take you to page 876. And this is an email dated the 9th of November 2021, and it's timed at 9:34 p.m., which is also exhibit 94 of Mr. Boris's witness statement. Your Honour, here you can see that it appears that the claimant's own proposal is to raise the LTV on the Landstone bonds to 80%, and that such facts, in our view, does require further investigation, because it says in the middle that raise the overall, if I can take you to the middle paragraph, if you like, and the second line from the bottom, it says raise, it was spelled incorrectly, the overall LTV on reinvestments from 70 to 80% through an AAV, which leaves an effective NR of USD 36 million.
Now, what does all that stand? What's an AAV?
So as we understand it, again, this is where we would say we do need a sort of a banking expert in the overall thing. But like we understand it's been an additional advanced value.
Right.
Yeah. So as I've said, and I won't make the point again, Your Honour, is that there presumably there's other communications and meeting notes which would likely arise out of this. And as a normal course in any claim, in any case proceeding, there would be a production or a disclosure exercise or phase. And the defendant's position is that more relevant and very important, pertinent information would arise out of these correspondences and communications. And again, if you know the purpose is to avoid a mini trial. So if there are sort of various factors, because this also raises various key questions, which again I have highlighted in my skeleton argument, but I don't wish to sort of go through these in term of you again for the sake of time and brevity. But there are key questions, and I'll just pick out a few, just by way of example. You know, was the LTV on the Landstone bond raised to 8%? And what was the LT value on the Landstone bond? And then if the Landstone bond did have a value, what led to the reduction of the LTV ratio? So there's a lot of questions which come which arise as a result of this. And our position is that after production has taken place, it is likely that an expert, a banking or a quantum expert, will then be appointed, and then both parties will put together certain questions which that expert would need to answer in order to come to a determination on the merits of the case. Because some of the other key points which we'd like to focus on here is that you know, the claimants have failed to provide any evidence at this stage, as far as we're aware, of market fluctuations, which again we would say would require a third-party analysis, a separate party to look at that, and also to see what the prices were of on the relevant dates for the relevant trading platforms, and then finally what impact such market fluctuations would have on the defendant's portfolio and what these ramifications would be. So yeah, so that's the first point. I'll finish that submission. The second point which I would like to raise as part of my submissions is this. As my learned friend has gone into some detail on this, but is the claimant's attempts to frustrate the defendant's refinancing efforts. Now, as is clear from the pleadings, the defendant's position is that the claimants have persistently tried to hinder efforts to transfer the account to another bank. And although my learned friend has taken us through some of the correspondence, there's clear correspondence which supports the opposite position, that there has been a delay, or there has been a very forceful, if not aggressive approach from the bank. So you want to hear what I would sort of focus on is that crucially the transfer of the account was taking place so that the first defendant's liabilities could be paid to the claimant by the transferee bank. So there's been a continuous focus of trying to resolve the situation. The defendants acknowledge that there was an issue, and with the likes of Credit Suisse and EFT, and they've continuously tried to do that. So the first defendant could be allowed to clear its liabilities so that we were at a more manageable level, say around 10 million during a transfer attempt to Credit Suisse. So I can take you to page 783 of the bundle.
Yes.
Yeah. Sorry, the bundle's a bit slow. So here we can see that there's just after the table, it reads, "We understand."
So this is an email from Credit Suisse to Bank of Singapore people.
Yeah, correct. You're right. Yeah,
okay.
Correct. Yeah. So this is so it says, "We have received instructions from our mutual client to receive the below securities through LOU and DVP from their account held with Bank of Singapore." The key point to stress is after the table, where it says, "We understood that we should pay back to Bank of Singapore approximately 10 million between the USD and Euro securities portions. Could you please confirm the exact amounts we should transfer to cover the payment?" So here we can see that, had the claimant allowed the transfer, the first defendant could have then been able to clear its liabilities to a much more manageable level. And it would have been much more commercial and palatable, and perhaps we wouldn't even have the need for this hearing today.
So let me understand what this is saying, Mr. Whitehead. So Credit Suisse, so we've received the instructions from our mutual client, so that's the first defendant, to receive the below securities from their account with the Bank of Singapore. So they've received instructions from the first defendant that those securities listed, which were held by the Bank of Singapore, should be transferred to Credit Suisse.
Correct.
And then they say that we should pay back to the Bank of Singapore approximately $10 million. So it's not, well, I think Mr. Montague-Smith put it, this is not for proposing a transfer of the whole of the first defendant's portfolio of securities or the repayment of the whole of the loans owing by the first defendant to the Bank of Singapore. It's a proposal for a transfer of some securities, and it's not clear whether it's to be contemporaneous, simultaneous, or more likely a subsequent payment by Credit Suisse to the Bank of Singapore of US $10 million.
Yeah, I think correct. Yeah, I think it was, as far as we understand it, was to cover the outstanding liabilities.
And what I hope I'm not verbalizing Mr. Montague-Smith, but I think one of the things he said was, why would the Bank of Singapore agree to release any securities when they were held as securities for the outstanding loans? It would be an uncommercial thing for the bank to do, wouldn't it? For the Bank of Singapore, it would be an uncommercial thing for them to do, to release securities which they held as security for outstanding loans. So we've got a pause. Are you able to hear me, Mr. Whitehead?
Yes, sorry, Your Honour. I thought
Right.
the question was posed to Mr. Montague-Smith.
No,
Shall
no,
I carry-
no.
Oh, sorry,
To you,
apologies.
I said I was hoping I
Okay.
wasn't verbling him.
Yeah, I'm quite right.
But
Absolutely.
I was
I mean, look,
attempting to pick up what he
Sorry.
had said. And I'll put it to you again, that as I
Yes.
understood one of the points he made was,
Yeah.
in effect, it would be uncommercial, perhaps even not sensible, for the Bank of Singapore to release securities which it held as security for the outstanding loans. It would be uncommercial for them to release those securities.
Perhaps. Yeah. What to be clear here, I think the defendant's position is that they don't dispute obviously the amounts are owed. It's just that the fact that these were unreasonably and unilaterally increased by the bank. That's the defendant's stance on that.
No, but I thought the point you were making here was this is in support of your submission that the Bank of Singapore frustrated attempts by the first defendant to refinance the loans. And you were taking me, you took me to this email as evidence in support of the proposition that the Bank of Singapore impeded, and perhaps we'd have to look if that's in some way unreasonable or improper, or in any event, that they impeded an attempt by the first defendant to refinance the loans. And what I was putting to you to seek assistance from you is that on its face, what that email appears to say is it's a request by Credit Suisse, or perhaps simply a notice that they've received instructions from the first defendant to receive those listed securities to be transferred from the Bank of Singapore to Credit Suisse. And then it says, we understood that we should pay back to the Bank of Singapore approximately $10 million. Now, on the face of it, I would have understood that to mean that what is being suggested is that the Bank of Singapore releases or transfers those securities to Credit Suisse, and then Credit Suisse in some way will pay back to the Bank of Singapore, I suppose it pay to the Bank of Singapore $10 million in reduction of the first defendant's loan. Now, if that's the way it should be read, why is that any wrongful, improper, or what's wrong with the conduct of the Bank of Singapore in not acceding to that request, if it's a request, when in effect what it's doing is asking that the Bank of Singapore should release securities which it holds as security for the outstanding loans?
Yeah, no, I take your point, Your Honour, on that point. If I can refer you to just page 799 of the bundle.
799. Yes.
Just before I address this document, I think our position in response to that is that the Bank of Singapore didn't actually reject that instruction. As far as we're aware.
Well, you were taking it to me, as I understood it, as evidence in support of the proposition that the Bank of Singapore impeded the transfer. So you take as evidence that the Bank of Singapore did something which impeded, frustrated the first defendant's attempts to restructure. And so far, I haven't gained anything from that email which shows that the Bank of Singapore did that.
So if you're on it, I will take you through the delays now, because that's I think that's the key point here. There has been delays on it. So if we can just look at page 799, this is an email from the Bank of Singapore to Credit Suisse, where they've said, please be advised that our legal team have marked up your LOU to align with Bank of Singapore's terms as per attached. Please kindly confirm it's acceptable from your side. We can accept different currencies as long as the total amount is not less than 10 million. Alternatively, is also acceptable. So here, and I'll go on to explain now that there were then delays on the part of the bank, is from the defendant's point of view on that, which has caused them to be put in this position. So
delays in doing what, Mr. Whitehead?
So delays in allowing the refund, allowing the Credit Suisse and the other banks to deal with the matter to refinance.
But what is being said there is we can accept different currencies as long as the total amount is less than $10 million. So isn't that in effect saying, well, pay us the currencies, pay us an amount, we'll accept it as long as it's not less than $10 million. So isn't the ball in the court of Credit Suisse or the first defendant to do that?
Correct. I think that's correct. But if I can just develop this line of argument, right, just to, again, because it's more about the delay point, which I'd just like to focus on. Sure. So essentially, as I've said, the defendants have said that the claims have hindered the defendant's efforts. And if I can take you to page 695 of the bundle.
Yes.
Yeah. Sorry, it's just a delay. So here, sorry, just the bundles inside. Yeah. So paragraph 314, it says, it reads, and this is the witness statement of Mr. Brooks on behalf of the claimant. It says, in fact, whenever the first defendant tried to transfer the portfolio, the claimant has always hindered the process.
Sorry, did you say
another example?
I'm sorry, did you say it's Mr. Brooks?
Yes. Oh, sorry, whose is it?
No,
oh,
so it's
Mr. Khan. So this is Dr. Khan's. Apologies,
Dr.
sir.
Khan,
yeah.
Thank you. Yes, yes.
Yeah. So it says, another example of this is portfolio transfer requests we submitted to the claimant in the first week of December 2021 for transfer to Credit Suisse. The claimant dragged this transfer on one pretext or another, and eventually the receiving bank had no other choice but to back out from the transfer. So on 12th of January 2022, Mr. Juma received an email from Credit Suisse requesting for help owing to the delay from the claimant in approving the transfer. On the 17th of January 2022, the managing director of Credit Suisse expressed his discontentment on the lack of a response from the claimant. Again, this is my point on the delay. Credit Suisse sent emails to the claimant on 10th, 11th, 12th, and 14th of January 2022, in addition to trying to reach them over the telephone. However, there was no response from the claimant. The claimant was therefore deliberately preventing the transfer of the portfolio. And another instance was when the first defendant wanted to transfer the portfolio to EFG, which I'll go on.
All right, can you take me back in that paragraph? You read, on 12th of January 2022, Mr. Juma received an email from Credit Suisse requesting for help owing to the delay from the claimant in approving the transfer. Then there's a reference to a document. Do you know what the page number is in the bundle for that?
Yes.
So I'd like to have a look at it and see if it supports what Dr. Khan says it does.
Yeah. If you just give us 2 minutes. It's page 711 of the bundle, Your Honour.
711.
Yes. 710 and then 711. So it's 2 pages because it spans over 2 pages. So this is an email 12th of January 2022, and it reads, Dear Mr. Juma, hope this email finds you well. Can I request you to help since we were unable to understand the reason of the delay on the part of the Bank of Singapore We have done every bit from our end. Your help and guidance is requested. And this is from Credit Suisse.
Yes, I see.
So I think what we're trying to say here, Your Honour, I think you've got the point, is that the claim has hindered the transfer process in December 2021, when the first defendant was requested the account to be transferred to Credit Suisse. And for this transfer, the claimant delayed the procedures to such an extent that the receiving bank, Credit Suisse, had then no choice but to abandon the transfer. If I can take you to page 710 of the bundle, Your Honour.
Yes.
Oh, sorry, apologies. This is the email I've just referred you to.
You did,
So
yes.
that's fine. So yeah, apologies. Yeah. So you preempted me, Your Honour.
Perhaps I should be a little more patient.
No, it's fine. Don't worry. So obviously the claimant required the first defendant to clear the outstanding balance before proceeding with the transfer. If we can refer you to page 775.
Yes.
Yeah. So this paragraph 12, it says in relation to
what document is this?
So this is Mr. Boris Herbert's
Right.
statement again. Yeah.
Yep.
It's in paragraph 12, and it reads, in relation to paragraph 314, a similar allegation arises. In December 2021, the first defendant wanted to transfer part of its liquid portfolio to Credit Suisse. An email dated 16th of December 2021 from Credit Suisse set out the relevant securities. As the first instruction letter did not include Apple shares, a revised instruction signed by the second defendant was sent, etc. The claimant was not prepared to transfer the portfolio until outstanding balance was cleared, and Dr. Hyder was fully aware that the claimant needed clarity on how margin shortfall was to be met and when the claimant would receive a coupon payment, or alternatively where additional security was to be provided from. So here, I think what we're trying to say, Your Honour, is that Credit Suisse requested the claimant to confirm the exact amount to be transferred so that it could cover the payment. And essentially, the claimant never indicated that they first wanted the defendant to clear the outstanding liabilities. And in fact, the correct position is that Credit Suisse would have cleared the liabilities on the first defendant's behalf. However, because the claimant delayed the process, Credit Suisse could not complete the transfer.
Is there evidence of that? That Credit Suisse offered to repay the outstanding loan or the margin deficit?
If I believe we can, if I can come back to that shortly, if I can.
All right.
We got that.
And if I'm taking you out of your steps, please step it out the way you intend.
So we've got another example, Your Honour, was from February to March 2022, and this is in respect to the EFG attempt.
Right. Yep.
So if I can take you to page 702 of the bundle.
Yes.
So this is the witness statement of Dr. Hyder, and it basically it stems from paragraph 3.48 to 3.53. But the main one which we'd like to sort of draw attention to is on 3.49, which is on page.
Yes, I have it.
Have you got it? Yeah. Okay, perfect. 702. So 349. So it reads, however, suddenly, Mr. Sani sent an email stopping the transfer of the securities and requesting the first defendant to first address the margin shortfall either by sale of securities or by SWIFT confirmation by Monday. I received this email at 10:14 on 11th of February 2022. As this email was received on a Friday, there was nothing I could do to arrange for a confirmation through SWIFT. I indicated so in my reply to the email of Mr. Sani. However, I did assure Mr. Sani that the first defendant would work with EFG to expedite transfers and aim to complete by Monday, the next working business day. I requested a call on that coming Monday on 14th of February 2022. So here, Your Honour, it appears as though the claimant, again, to support my argument, arbitrarily halted the transfer to EFG, despite the assurances which were given by the claimant that the first defendant would meet the magic cause after the transfer, and then the claimant refused to proceed with the transfer.
So who gave the
key thing here
who
is
gave the assurance that they would meet the margin deficit?
the defendants, Your Honour, sorry. The defendants. Right. So
and where is the evidence of that? Have we got some email or letter of them saying that?
We can, we will come to that. I'll find that. So I think the point we're trying to make here, though, is from any practical, reasonable point of view, there was an extremely unrealistic and short deadline which was given, within which they were required to meet the margin call. As they were told to address the margin call before Monday, the 14th, and before the claimant could agree to the transfer. So yeah, exactly. So there was an email also sent by Mr. Sani for the claimant, again, which I've said on Friday night, and therefore any arrangement of funds could just not take place. It was just impractical to allow such funds to take place. So there's one more example I'd like to just draw your attention to, Your Honour, which is at page 634. And this relates to the attempt to transfer the account to one Swiss bank and to Deutsche Bank, or Deutsche Bank.
This is the email of 27th of June at 9:22. Is that it? One at the top of the page.
Ours is still loading, Your Honour, so just bear
with us. All right.
Yeah.
I had a similar problem. That's why I downloaded a copy.
Yeah, I think that's sensible. So yeah, so I've got the paper version here, Your Honour.
Okay.
This is an email, as you quite rightly point out, on the 27th of June 2022. And it reads, please find attached the TS from DB Lux. As discussed during our last video call, we will proceed with DB if things at Swiss 1 doesn't materialize within the first week of July. Your understanding and help is much appreciated. So this is from Dr. Hyder. And then it goes on in the pages after that, it's 635 to give you this essentially meeting confirmation details. But at the bottom of page 635, it says, we will, however, request Bank of Singapore to please extend this deadline to 7th of July to allow us transfers out to either Swiss 1 or an alternative bank we are dealing with, or to replenish the account with cash and taking the non-liquid securities out during this period to continue the relationship with you. And then it makes various reasons for making this request, which are all valid and legitimate. The bank we are dealing with is the same that took over portfolio in the past. The liquid notes are going to their global markets and residual to the private bank. The traders approved at their end, and we are waiting for the execution documents being prepared by their external lawyers due to multi-jurisdictional requirements. So it's clear, obviously, there's a lot of factors at play. There's a lot of things need to be considered. We will share their offer in the next few days. And then you can see on the next page at 636, This is an indicative term sheet, which is from Deutsche Bank, where the lending facilities are confirmed. So I think the point we're trying to make here is that the claim is always
chicken and egg about. Is there some chicken and egg about this? I see that the facility amount is up to 224 million euros, subject to sufficient collateral. And part of some of these communications are requests by Bank of Singapore to transfer the securities, and Bank of Singapore are saying, and some of these suggestions seem to be give us the securities and then we'll give you the money.
Sure, yeah,
can understand why it doesn't come to pass.
Yeah, well, quite right. I mean, that is the problem. The point we're trying to make is that the claimant was always kept very well informed of the status of the transfers. It wasn't cloak and dagger. There wasn't any sort of misapprehension in terms of what was going on. It was very clear what was trying to be done and the efforts which were trying to be made. However, I think the main pain point, if you like, is that the first defendant's efforts were disregarded, and there was this demand notice which was issued on the 15th of June 2022 to request a payment.
Mm-hmm.
So the claimant has alleged that it did not object to the first defendant's transferring its account to one Swiss bank, but our position is that this is not the case. If I can take you to page 775 of the bundle, and this is paragraph 11 of Mr. Boris's witness statement. I think, sorry, I've already gone through that, so I don't think there's any need to refer to that again. Sorry, we've considered that. So here, I mean, the claimant admits, Your Honour, that has no objection to the first defendant transferring the account to one Swiss bank, and that its liabilities to the claimant will be settled. So the claimant understood the whole purpose for transferring the account was so that the liabilities could be cleared. That was in both parties' best interests. There's no doubt in that. But a key question, which we feel is yet to be addressed and that needs to be determined, is why the claimant would try and hinder the transfers. You know, as you've referred, this chicken and egg scenario, it was almost like it would never come to fruition. The underlying concern from the defendant's part is that in reality the claimant had no intention of allowing the defendant to obtain a refinancing structure. Again, the defendant's position is...
Mr. White, if the Bank of Singapore's position, if the facts of the correspondence, the emails, so on, and the evidence, if that leads to the conclusion that put at a high level of generality, the Bank of Singapore's position was we will transfer the securities after you have paid the outstanding amount. Is there something wrong with that? Is there some breach of contract or some breach of duty, or is there some wrongful conduct by the Bank of Singapore if that was their position?
Sorry, Your Honour, I only caught the last part of what you said because there was an error in the work of the internet.
All right. If the evidence, both the witness statements and in particular the documents, if they show that, taken at a high level of generality, the Bank of Singapore's position was we will transfer the securities out of our account into that of another bank after the outstanding loans have been repaid, if that was their position, does that amount to any breach of contract, breach of duty, or wrongful act by the Bank of Singapore?
No, I think it's obviously it's subject to contract, isn't it? Provided they comply with the contract. We've raised these implied term arguments, but prima facie, that that's what the bank it's the bank's decision. As a lender, if it decides to do that. But I think what we would say here is that there's key sort of points and facts which have arisen as a result of this, which do require further investigation. And obviously, it would mitigate the defendant's loss, which are important. And again, to avoid having to conduct a mini trial on these factors. So that's my second submission, Your Honour. My third submission is to do with the misrepresentation by the claimant or our purported in relation to the Landstone and the Nord Rock bonds. So our position here is that there has been a clear misrepresentation, as because the defendants fraudulently represented that the Landstock bonds were not in default. We say this is incorrect, Your Honour. The defendants were advised by the issuer that the Landstone bonds were not in default and checked the information on the public platform.
No, I'm sorry. I'm sorry. Yeah. Maybe I wasn't concentrating enough there. Yeah. Now, you're talking about misrepresentation.
Yes.
What misrepresentation by who to who are you referring to?
So what we're saying here, and if I can take you to page 760, we're saying that there has been a misrepresentation by the claimant in relation to the Landstone and Nord Rock bonds.
Right.
If on 760.
Right.
Yeah. And this is also exhibit DA251. So this relates to this is a trading team email from in respect of Landstone. And what we're saying here is it's underlined. It says full nominal outstanding guaranteed by asset pledge and insured financial guarantee. And it also references the outstanding.
Yeah.
Yeah. So what we're saying here, Your Honour, is that the claimant has misrepresented that the defendants fraudulently represented that the Landstone bonds were not in default. Because basically the defendants were advised by the issuer that the Landstone bond was not in default and checked the information on the public platform, which did record that the Landstone bonds were not in default.
So this, you're going to have to explain this document to me, I'm afraid, Mr. Whitehead. What is this? This is a...
I think this is, yeah, so my learned friend, I think he took us to this earlier, and again, we've only been provided with this last Friday. Oh, sorry, that's incorrect. Sorry, we have had this before. So this, as we understand it, is bond information, and it relates to the Landstone BV, and it's industry, obviously financial, and it has at the bottom holders. And
so this is and this, just so that I understand it.
Yeah.
It's an email. I mean the picture, the image that appears presumably comes from somewhere, but the email is internal to the defendants, or at least their parent company. No, I see.
Sorry, yeah.
Sorry, if I can help. Can I assist? Sorry, I don't mean to interrupt.
No,
Mr. Whitehead, are you happy for Mr. Mr. Montague-Smith to do that? Yes, Mr. Montague-Smith.
Thank you. So this document was produced by Mr. Hubscher, And it is the statement it supports is in his witness statement, paragraph 3.38, which you'll find at page 700. And the point that Mr. Hoopshire is making is that publicly available information did not give any indication of a default on the bond.
Oh, I see.
And so this is a printout, I think, from the Bloomberg trading platform.
It is. Yeah,
Thank you.
Yeah.
I
think.
Yeah.
Yeah. Sorry. I think it is. It is from Dr. Hyder's statement, though, as well. So it's at D. It's at exhibit DA251. Yeah. So I think
you're quite right. Thank you. You're absolutely right. So this is the defendant's document. You're absolutely right.
Yeah. Thank you. So I think what we're trying to say here, Your Honour, is that it shows that it was not in default at that time, at the time of the the Bloomberg publicly available screenshot, as it were. Yeah, although it's in an email. So it wasn't in default at that time. You can see it's not in default there. Because it's at the bottom in capitals, it says full nominal outstanding guaranteed by asset pledge and reinsured financial guarantee.
Right.
Yeah. So what we say here, Your Honour, even if the bonds were given as collateral, the claimant did not then utilise that collateral. So in Mr. Boris's second witness statement, he claims that it was not possible to sell the bonds as no counterparty was willing to buy these bonds. And I can take it to page 776 of the bundle.
Yes.
Yeah.
And whose statement is this?
So this is Mr. Boris Haber's
Hoopshire.
statement. Yeah.
Yep.
So paragraph 19, it reads, I note that Dr. Hyder asserts that the sums claimed are incorrect. And if I can take it to the final three sentences, it reads, it was not possible to sell the Landstone or Nordrock bonds as no counterparty was quoting a price or was willing to buy these bonds. So the defendant's position in response is that these were sizable bonds in terms of value, and it would be unfair for the claimants to be punished, for the defendant to be punished for the claimant's inability to sell the bonds. So that there's questions which arise from that. It's unclear.
One of the points, one of the submissions Mr. Montague-Smith made was that the claimant had a right to sell the bonds, but no obligation to do so. What do you say about that?
So I think with that, we would say that it's again a good faith argument. We would say that it would be incumbent on the bank to try and remedy the situation as much as possible, and to ensure that if they could sell, they would. So they've got a duty to do so.
Where does that duty come from?
So we would say again, and I'll come on to this submission later because it'll depend on what law applies. Okay. So I want to be quite careful about addressing that point. But I think what we're trying to say here is that there's clear questions which would likely arise, and that risks this mini trial point. And I can go. I've raised these in my skeleton, but I'll go through a few now. Is whether the bonds were agreed between the parties to be collateral for the facility, and also the contractual provisions. So what law, what is the position under the relevant laws? And obviously, as we've referred to, it is under the law of Singapore. So we would, in our view, need an expert opinion from a Singaporean lawyer on perhaps this point and a number of other points in this case, given that the governing law of the contract is Singaporean law.
But do you say that let me see if I understand it. Do you say that there is some Singapore law which gives rise to a duty on the part of the bank to do something?
Well, we've not addressed that, Your Honour, just for the simple fact that I'm not a qualified Singaporean lawyer, so I couldn't go beyond. Yeah.
But this claim was made, I don't know, some time ago. It's not like you haven't had an opportunity to investigate what Singapore law is, but you've chosen, or you've not brought forward any evidence of Singapore law or anything to suggest that there is any law as part of the law of Singapore which would be relevant to this. That's mere supposition, isn't it? Or perhaps it doesn't even raise that high. You're saying maybe, possibly, could be.
Yeah, I appreciate that. I think we obviously we were engaged after the initial pleadings was filed, and we're engaged also at the immediate judgment stage. Now that's no excuse, but at the same time we would say that it would likely require a Singaporean lawyer to give an expert opinion on certain
About
key
what?
things.
Yes,
Well,
about what are those points?
So I think the duty, whether there's been breach of duties, all these points, there's a lot of different legal factors which we need to, which I will come on to develop in my submissions.
All right.
Okay. So in terms of, the claimants have also produced a table of solid liquid securities which have held in the MARJ account. If I can take you to page 114, Your Honour, of the bundle.
Yes.
So this lists all the securities.
Now again, what document are we looking at?
So this is Mr. Boris for the bank, the witness for the bank. Yeah. So he this lists all the securities. Now if we can have that in mind, I don't know if you can create two tabs so we can look at two documents at the same time, another tab on your internet screen. But if I can take you to page 746 of the bundle.
You're going to have to bear with me for a moment.
Yeah.
It's not quite as easy as I had thought.
No problem.
What page do you want me to go to?
So there's 2 pages if we can look at side by side, if at all possible. Perhaps if you could, I don't know if you can do this, Your Honour, but if you create 2 tabs at the top of your screen and copy the hyperlink into both tabs, it might allow you to look at both.
Well, I've opened it on another laptop to try and avoid losing the document altogether. What's the other page you want me to look at?
Yeah, so there's 2 pages. So there's 746, and then there's page 114.
Yes. Okay.
So yeah, so we've looked at 114, which is from the witness statement of Mr. Boris, and page 746. This lists 9 securities, and this was sent by Mr. Satney to the defendants and lists in this email. So you can see there's 6 securities which are not there, which have gone. Again, we're not sure why they're not referred to, but there's also securities sold. Also, the securities sold that we need to question whether the securities were sold at a fair price. That's one of the key points here.
Well, you haven't raised any allegation to that effect, have you?
We've not, as far as I'm aware. Well, that is something we would raise as part of, and that's what we would want. We wanted to raise that as further submissions, but so yeah, that is something we would like to address. But the other point
but you've had an opportunity to do that, and you've not done it. I don't mean you personally, of course, but your clients have had an opportunity to do that, and they've not raised any allegation that the securities were not realised for a proper price.
I think there has been the evidence which came in last Friday has raised a lot of these niggles and additional points, which has caused these points to be raised today in the hearing. Because the other point here, if we could look at the Apple Inc. Point, so
right
here it confirms that the quantity in Mr. Boris's statement, it confirms that the quantity on the 3rd of October 2022 was 9.9 million.
Yes.
Yeah. However, the quantity as given in the email, which is only 10 days later, was 75,000 USD. Now, again, I'm not a bank.
Sorry, that's not a dollar figure. That's 75,000 shares or stock or whatever.
So apologies. Yeah.
So in the state. Sorry to interrupt again. In the statement, it's not saying the 9.9 million shares in Apple. That would be quite a lot of money. That's 9,900 with 3 zeros instead of 2. That's all it is. It's not unfortunately, there were not 10 million Apple shares in the account. We would really not be here if there were.
There were 9,900. Yes, I see.
9,900. Okay, fine. But then it says 75,000.
Yes.
So there's a big discrepancy. Is the point? I mean, it's nearly 60,000 more, isn't it? It was I'm not really maths, but what the point here is that there's a huge difference in 10 days. And what we say as the defendants is that it would need an expert in banking or quantum to delve into this and really understand the detail.
I don't understand that.
So, sorry to interrupt again. If the submission is that there's a 10-day gap between these two documents, that's just completely wrong. So the first document is dated, you will see, 2021. So this is 13th of October at the beginning of all trading activity. And so I think my learned friend's point is that a year and 22 days later, you've got, or whatever it is, there's then less securities in the account. It's not a 10-day gap. It's a year. It's the whole trading of the entire account.
I can see that. I can see that.
Is that right, Mr. Whitehead?
Yeah.
All right.
Yeah. Sorry. Yeah. My learned friend's quite right. Yeah. So anyway, but the point still remains that there's a lot of banking related issues which we feel need to be examined. So that's my fourth.
I don't know. You say they're banking related issues. They seem to me to be more matters of arithmetic or
yes,
looking at share prices on a certain day, which if you've got a Bloomberg subscription, you can do that in a pretty short time.
Yeah. Yeah, there are other points which I'll develop for you on that. But I'll take your point. It is more there's a lot of arithmetic which needs to be looked at in that respect.
Well, I don't understand that. I don't understand that either. I mean, you don't need an expert to do arithmetic, and you don't need a great deal of time to do it. If you look up what the prices were on a particular day, multiply prices by numbers. If you've got a calculator, it takes you less than a minute.
Look, we would say that there just needs to be more evidence to look at on that, because there's a lot of other points which we need to consider there. But if I can move on to my fourth point, Your Honour.
Yes.
This is to do with this unauthorised communications between the to the issuers of the bonds. So here, I think my learned friend raised the point that there shouldn't be any issue in terms of communicating with an issuer or a bond issuer, and we note here that the claimant has admitted that it approached the CEO of the Landmark Group, which was the issuer of the Landstone bonds, and did identify, if I can take you to paragraphs 107.
So page 107 in the bundle?
Sorry, page 107, yes.
Yes. What's that document?
So this is so this is basically so this is a witness statement of Mr. Boris.
Yes.
And here it essentially confirms that there was communication at paragraph 36.
Yes.
It says on 30th of September 2022, the claimant was informed in an email from the CEO of the Landmark Group that ARG Holdings Limited had not paid for any of the bonds issued and the bonds issued, etc. Furthermore, on 7th of December 2022, the bank was informed in an email by the insurance broker for the Landstone bonds that the bonds had not been paid. Yeah. So other than, there was also confirmation from excuse my pronunciation, Kola Jamkoma and partners, that several Landstone bonds were fully paid up by ARG Holdings Limited, but the one inquired by the client was not fully paid up. And that's it, page 107 of the bundle. And also the other reference is page 500 of the bundle.
Page 500.
Yeah.
That's an email.
So I'm just loading up.
Right.
What I'll go on to say here, just while it's loading up, basically, other than these two emails, there's no other or further documents provided by the claimant which cause into question the veracity of these allegations. So,
well, can I go back? Can I just try and help me with this? You said that this is your fourth submission and it goes to unauthorized communications. Yes. What I would like you to do, help me by identifying the communications which you're complaining about and why they're unauthorized or why that's a breach of some duty or what the consequence of it is. So can we start with what are the communications you're referring to?
Yeah, fine. So if I can take you to page 494 of the bundle.
494?
Yeah, 494. So this is an email from Landmark Group.
Yes.
And if we read the first line, thank you for your email below. We are pleased to note that Bank of Singapore wishes to adopt a pragmatic and cooperative approach in order to protect its interests, as well as we hope the interests of Landmark Group. Whilst we note and are grateful for your willingness to sign an NDA, at present we are not able to share a copy of the bond sale agreements in place with ARG Holding Limited. Now, why would an NDA be referred to if there wasn't a potential confidentiality issue?
Well, I assume from that, and it might be just the way I read that, is that the Landmark Group are saying, in effect, we have got some confidential information that we are not able to give you that information. You, Bank of Singapore, have indicated you're willing to sign an NDA, that is, that they wouldn't disclose the information given to them by Landmark. That's what I read that paragraph to mean. But so I'm trying to start with what the communication is. Is it a communication from the Bank of Singapore to LAMAC, or is it a communication from LAMAC to the Bank of Singapore, or what communication are you complaining about?
So I think it's in reply to an email, if I can take you to paragraph 495 of the bundle.
495.
495, yeah.
Yes.
So here,
yep.
Yeah, so it's from Mr. Alexandra of Bank of Singapore.
Yes.
And in the third paragraph, so it says, Dear Lars, and in the third paragraph, it says, in order to explore further options, I would like to request you for the following. Could you share a copy of your agreement between your company and the buyer of the bonds? We can sign an NDA if required.
Yes.
So I think that's what it relates. That's the
yeah.
You know.
But what is the communication you're complaining of? Is it this email of the 26th of September?
What is the, sorry, Your Honour, what's the...
Well, what I'm trying to get in my head, as I understand it, if you're talking about unauthorised communication, the starting point is to identify the communication. Then we can look at whether it's unauthorised, and if it was, we can look at whether that's a breach of some duty or what the consequence of it is. But I really need to come to grips with what is the communication you're referring to, complaining about. Is it that email? Is it something else?
Yeah, well, I think it's sort of, if we go to 496, the communication surrounding that it all relates to that. So it relates to a high level agenda for the meeting would be introduction to the bank, introduction to LAMAG Group and business strategy and information.
Sorry, where are you reading
so,
from? Oh, I see. So
yeah,
this is again from the
496.
Yeah.
Yes. So it says, thank you for your confirmation. The high level agenda for the meeting will be introduction to our bank, introduction to LAMAG Group, and information about Landstone and Nord Rock bonds.
Right.
So I think that's it. Look, I don't want to dwell on this argument. It's not, you know, I think I'll just move on if I may, Your Honour. I don't from this submission.
Well,
because I'm conscious of time. Yeah.
Yes, but time is one thing. Ensuring that you have a proper opportunity to put your case is more important. And at the moment, I'm in this position that I've received a submission that there was an unauthorised communication and that has some consequence. But for the moment, I have to tell you, I'm not able to identify, I don't know what the unauthorised communication was. So if we leave it at that, or if you leave it at that, I'm not going to be able to find that there was some unauthorised communication or what the consequence of it is. But it's your case and you can move on if you wish, but
no,
I want to make it clear to you that that's where I'm at the moment.
Yeah, no, I understand. I might come back to that point.
All right.
So the next point that I would like to make is that there was a failure by the claimant to load the limits. This is the fifth argument that I would like to make under the facilities. Yes. So this here, the defendant's position is that the claimant failed to make the required limits available on the defendant's account, and this resulted in a loss of trading opportunity for the first defendant. In particular, on this, there was on the 13th of October, the limit on the first defendant's portfolio was $1 million, which is only 2% of the amount of the $5 million that the claimant was required to make available, which Your Honour is aware of. If I can take Your Honour to...
Well, no, I think Mr. Montague Smith submitted that the claimant wasn't required to make anything available. It was an uncommitted loan with advances at the discretion of the bank. That's the claimant's position. On their position, they weren't required in the sense of they were under no contractual or legal obligation to advance any amount. Do you contest that?
Well, we would, I mean, look, we would say that the claimant did agree to make 120 million available if additional securities were transferred. So there were sort of further communications, and basically, despite the defendant's assurances that the securities would be transferred, the claimant continued to withhold the 120 million. So what we're saying here is that there are very important points to be investigated and need to be considered. And as we've discussed earlier, and again, this is perhaps a point for an expert on Singaporean law, but whether the claimant was in breach of the facility agreement by failing to provide the agreed upon limit of 5 million. That's one of the first points, and whether the defendant suffered loss of trading opportunities due to the claimant's breach, and if yes, the extent of that loss. So essentially a loss of opportunity. And a number of other, if the claimant was liable to compensate the defendant for the loss. And
can I take a step to the side for the moment? And you've made reference to Singapore law on a number of occasions. Mr. Montague-Smith told me, and he referred me to a decision of the Court of Appeal, which I'll look at, to the effect that the law in this jurisdiction is not that which I'm familiar with. That is, it's not the position that in the absence of evidence of foreign law, the foreign law is assumed to be the same as in the forum. But assuming that to be so, the position, it seems to me, that I should proceed on is this, that to my knowledge, and I would have thought it's a matter that is well known, the law of Singapore is the common law altered by statutory enactments in Singapore. In the absence of either of you directing me to any relevant statutes in Singapore, it seems to me I should proceed on the basis that the law is the common law position. So when I come to look at questions of contract, of implied terms and so on, I do so on the assumption that it's the common law as applied in England and other Anglo countries without any statutory provisions. That's the approach I'm currently intending to take. As I say, I'm going to, and perhaps I can foreshadow now, I do intend to reserve this decision and read the Court of Appeal decision that Mr. Montague-Smith has referred me to. But provisionally, that's the way it seems to me.
Yeah, I understand. We would, because we weren't aware that that authority isn't part of the bundle, as far as I'm aware. So we would, and we would like the chance to review that as well, so that we could, if we need to make submissions on that, because I think that is a very important point in this hearing.
That is, what is the point that, what should the court take to be the law of Singapore?
Yeah, or the governing law. Yeah. Because
well, we know the governing law.
Yes.
It's common ground. I think the governing law is the law of Singapore.
Yes.
The question is what the court should take to be the law of Singapore.
Yes. Yeah.
Well, as I've said, I intend to reserve the decision. I can give you, I am busy on other matters tomorrow, and I do have some other commitments. I can give you till, say, Monday to send in a note, if you wish, on that point. And to be clear, let's be clear what the point is. It is, as I understand it, common ground that the law to be applied, the governing law of the contract is the law of Singapore.
Yep.
And Mr. Montague Smith has told me that the approach the court should take in determining what is the relevant law is that which is set out in Fidel and Felicia, referred to at paragraph 103, I think. Yes, of the ENBD case.
Yes, you're
now,
on page 1364.
Page 136. Yes, I do have that. Thank you. Now, I will let you send in a note if you wish by Monday, whether that is correct or not. That is, whether the position set out in the Fidel and Felicia case as to what law the court should apply when the law of a foreign law governs the contract. So
I think
I understand that's a very narrow point.
Yeah.
But if you wish to, I will give you until Monday. So you'll have to roll up the sleeves tomorrow, and you can send in to the court a note about that if you wish.
Thank you, Your Honour. I think we just need to obviously review the point is but I appreciate that. Thank you. Your Honour, I'd like to just move on to my next point, which is the sixth argument, which is the claimant's contention that the margin calls were not adequately met by the first defendant, were not met. This as far as the defendants are concerned is incorrect, because margin calls were constantly issued and in parts were being met, but because there were more margin calls being issued, they weren't being, the eventual one wasn't being met. So if I can take you to 564 of the bundle, and this is Dr. Hyder's witness statement.
Yes.
So here, sorry, our screen is just loading. So this is an email to Mr. Satni from the Bank of Singapore, and it says, please find attached a transfer instruction to transfer 10 million tomorrow morning back to the account. There is no more margin deficit, and we have also sold almost 4 million equities to cover any shortfall. The residual portfolio will be transferred in the coming week. So there were margin calls, but these were being met, defendants, despite the very strict terms which were imposed by the claimant. I think there are other examples, but I think that's a clear example of where it had been met. So that's the.
Sorry, maybe I wasn't concentrating. So this is an email.
So it's on page 564.
At the top of the page.
Yes, 564.
The 18th of March, 1219.
Yeah.
An email from Manoj to Ducha. Who is that?
Your Honour, so it's not that email we're focusing on here. It's the one in the middle of the correspondence.
Okay.
So apologies. I should have taken note of that. I'm sorry. So,
yep, okay.
So here, it's to Mr. Satni at the Bank of Singapore.
Yes.
Yeah. And it reads, please find attached the transfer instruction to transfer 10 million tomorrow morning back to the account of Mr. There is no more margin deficit, and we have sold almost 4 million equities to cover any shortfall. The residual portfolio will be transferred in the coming week.
Hmm?
Yeah. So the defendant's position is that it has consistently met margin call requests. However, as I said, the margin calls were kept being requested, which caused the issue which we're faced with today. And obviously, simultaneously with this, the first defendant was also trying to transfer the portfolio to other banks, as we've explained previously with Credit Suisse. So that's
Mr. Whitehead,
yeah.
if there was a margin deficit, was the bank not entitled to require it's to be put back in order each time it happened? And if there were repeated calls because it repeatedly happened, is there any fault on the part of the bank in doing that?
I think, again, as we've pointed out, I think obviously it's the bank's prerogative whether it wishes to do that and whether it's right to do that. But I think the point here we're trying to make is that the defendants were clearly trying to remedy and rectify the position and then put the position back into a solvent state, essentially.
All right.
So I think the seventh issue we'd like to make is the this guarantee and it being executed due to a failure. So the witness point, so that the D point, if you like. Now, if I could take you to the witness statement of Mr. Sartney and page 687 of the bundle.
Yes.
So here, Mr. Sartney. So it's on the final paragraph in paragraph 4. So it's on page 688. It reads, paragraph 4, upon returning to the claimant's office, I added my own signature to the deed of guarantee to confirm that the second defendant had signed it in the presence as a witness.
In my presence as a witness.
In my presence as a witness. So he's confirmed in his statement that he's confirmed the correct position in his witness statement. Now he's admitted that he didn't sign the guarantee when the second defendant allegedly signed the guarantee, and that
no, sorry. I'm not sure I understand what you're saying. What he says, we go back in paragraph 3. On the 6th of October, I attended the office of the first defendant and witnessed the second defendant, Mr. Juma, signing the personal guarantee. So he says, I witnessed Mr. Juma signing the personal guarantee. And then he says, I returned to the claimant's office and I there added my own signature to the deed of guarantee to confirm that the second defendant had signed it in my presence as a witness. So what's wrong with that?
So well, as far as we understand the claimant's case to be, is that he provided his signature after the execution of the deed. That's what we understood the position to be.
He added his signature to the guarantee after Mr. Juma had signed the guarantee.
Correct.
I would have thought that's always the case, isn't it? A witness doesn't sign something before the person. Now, I thought your complaint was something to the effect that it was too long afterwards, or that he should have added his signature to the document whilst he was still in the presence of Mr. Juma.
Yeah, sorry.
But I don't know of any legal requirement for that. The legal requirement for a deed to be valid, if a signature is required, is that the guarantor should have signed it in the presence of the witness. But I don't know of any requirement that the witness is to sign it in the presence of the guarantor.
I think just to make clear our position on this, our view is that it should be signed simultaneously. So it should have been signed at the same time. But
Well,
also,
I take it by that you mean as soon as possible after. Again,
yeah.
I don't assume they don't both have their pens hovering over the document, doing it at the same time.
Well,
so presumably, what you're saying is that Mr. Juma should have signed it, and then very soon afterwards, the witness should have signed it. But
correct.
What principle or authority do you have for that purpose? To that effect?
Yeah, so because we would say that needs to be considered by a Singaporean lawyer who can advise on what the requirements are for signing deeds, because given under the governing law provision.
But that seems to me, with the greatest respect, Mr. Whitehead, rank conjecture that there should be any requirement in Singapore law that the witness should have still been in the presence of the guarantor when the witness added his signature.
There is one other point we'd just like to raise on this, and again, this isn't one of is the fact that it appears it shows the address of the claimant on the document as well, and is it not a potential conflict there if that he's signing as a witness and he's using the address of the bank?
Well, again, I'm not aware of any law, any principle to that effect. You'd have to take me to that. I mean, he's only, all that Mr. Sani is doing is witnessing the execution of the document, and I know of no authority that an employee of one party to a transaction is incompetent to witness the signature of another, and doesn't seem to me in principle that there should be any such restriction.
I mean, the way we approached it, and again, I am being very tentative because I can't make.
And can I say also, I'm trying to dredge my mind through everyday experience. I think it's a common practice, isn't it, for when people go to execute documents at banks, that a bank employee witnesses their signature. I rather suspect Commerce would be running into a bit of a problem if there was a principle to the effect that you are putting forward.
I think that's probably right, but we can't make submissions because I'm not obviously qualified in Singaporean law. Right. So these are just points we found which perhaps needed to be further investigated. Right. Because obviously the claimant is effectively the beneficiary of the guarantee, and yes, that's right. Why we would say as an employee. So I won't consider. I'll finish that line by you. So there are main submissions.
Do you want to say something about the implication of terms? Mr. Montague-Smith, both in his skeleton and his oral submissions, has made submissions to the effect that the terms which you variously say should be implied should, as a matter of law, not be implied. Now, you've said something about that in your skeleton. Yes. Do you want to rest on what you say in your skeleton, or do you want to add anything to it?
I think I think a lot of the points we've raised in the pleadings on that on the implied terms. So I think our position on that is that it isn't the case that they are excluded. That you can have implied terms into contracts. It's very standard, and you know, from my experience, regardless of any exclusions, there are still implied terms in contracts. It's basic contract law. So our position remains as per the defence and counterclaim where we pleaded that. Yeah.
All right. Was there anything else you wanted to add?
No, Your Honour, they're my submissions. Unless you've got any further questions for me, they're my submissions.
All right. Well, unless either of you wants to make any further submission, what I propose to do, I've said that I will give leave to the respondents to file a note by Monday, which what's today is the 12th, I think, isn't it?
Yeah.
Is that the 16th of October?
Yes.
If you wish, you can, you're not obliged to do so, but if you wish, you may send in a note on the question of whether is the foreign law to be applied by this court as set out in the decision in Fidel and Felicia, which has been referred to.
Yes.
Anything you want to say about that, Mr. Montague-Smith?
Yeah. Well, Your Honour, I did have a few very short reply submissions. If you'll allow me, if you'll indulge me.
I'll come to that in a minute.
Thank you.
I just want to deal with this point. Do you want to say anything about that leave I'm giving?
Oh no, I'm very happy for you to do that. Of course, any assistance we can give you. If you're expecting anything further from us, though, well, my submissions are simply you can read that paragraph, and that is a decision of the Court of Appeal from this year.
So that's what I intend to do, but I say I want to give Mr. Whitehead an opportunity if there's something else he wants to draw my attention to, then he may do so.
Understood. Very good.
All right. Well, yes, I will indeed. Any reply submissions you wish to make, Mr. Montague-Smith?
Thank you. And you've got the substance of my main submissions, and I make it clear. I make no criticism of Mr. Whitehead. He's in a very difficult position, and we've all been in that position, I'm sure, in one form or another. And he's picking up a case which has been pleaded out by somebody else, and it is a difficult job that he is faced with. So that doesn't detract, though, and in fact rather reinforces the reality of the position that you're faced with, Your Honour, which is that you are faced with a case where there is no real defence here. I would like to just pick up on one or two of the points that were made. Yeah. One is in relation to the timing of evidence, and I just make the point, if Your Honour has page 87 of the bundle, you will see there the latest order of directions. And so, sorry, the order starts on the previous page, but you'll see the claimant shall file and serve evidence in reply to the defendant's evidence and answer by no later than the 9th of October. So that was an agreed order, consent order that was entered into.
When was, so that was after the Mr. Hubish's last statement, was it?
Yeah, no. So what happened was this order itself was made on the 5th of September.
Oh, this is the 5th of September.
The order was made on the 5th of September.
Oh,
so the reply evidence date that was set by agreement was the 9th of October, which is Monday of this week.
Oh, I see.
We, in fact, served our evidence in advance of that. We served our evidence early. Right. Now, yes, it's fairly soon before the hearing, but part of the reason for that was because the evidence timetable had to be shifted back to allow the defendants some additional time to put their evidence in. So that's why it got compressed. So if you go back to page 84, you see that there's the first extension of time. And you see that the time to file evidence in answer to the application was extended to the 4th of September.
Oh, I see.
And this is an application that was made some time before, so they would normally have 28 days to respond. I think this was made in May or June, so they were given a lot of extra time, and then they got another extension, you will see on page 86, which pushed it back from the 4th to the 11th. And that was the one that then set the time for the 9th. And it's right that I think that the listing took place after that date, so it wasn't anticipated that there would be such a compressed timetable. We did try to accommodate everybody by pulling forward the date for exchange of evidence, but ultimately These are consent orders, and we complied with them all. And the other point is that the defendants did in fact write to the court and ask for an adjournment of this hearing, and we're not back. So they've already had that application and been refused. So just to be clear on that. In relation to the point that I took particular exception to, I would suggest that we read the particular paragraph of the defence in a very different way from my learned friend, but we are grateful for the indication that he has given that his client does not allege that the bank has been dishonest, and that is obviously of some importance for the bank. So we are grateful for that public indication. I think that my own friend sought to, in terms of the so-called revaluation of the collateral, he sought to suggest that there had been at some point an indication that the bank intended to raise the value of the bond LTV to 80%. He took you to page 876 of that and showed you some particular aspects of it. I think that the first point, obviously, is it doesn't really matter what the bank intended. What matters is what it did. But in any event, you can see at the bottom of that page, whatever he may have made of the rest of the detail of that correspondence, the conclusion from the bank in relation to its internal correspondence, what was being internally applied for on behalf of the client, the conclusion, the last bullet there, the account positions would be as follows: total exposure gets capped at 200 million and NR capped at 60 million. So across the whole piece, the total exposure would be 200 million. There's no suggestion that we were going to lend 70% of 200 just against this bond.
So what's NR?
I did know that. It's the something. I'm sorry, I've lost it. Yeah, what is NR? You're absolutely right. You've asked the right question, but I don't have the answer to that. I think but I think the important point is that if one goes down to 893, one sees the outcome of this application process altogether. And you see Mr. Hubscher there approving the credit application and says the new AAV, so advance value, of 60 million for 6 months by way of 30% AR for security, and then identifies the bonds with 100% concentration cap for the time being. So it's an exception that's been granted for 6 months, which attributes a 60 million advance value to these bonds. So there's and then I've shown you also the subsequent documents which start at 896, which provide the actual margin statements and identify at the various points firstly the same valuation, and secondly the same advance ratio, which is the LTV, as my own friend calls it. So it's always 200 million and it's always an LTV of 30%. So there's no change that is applied to that other than to grant these exceptions, which I took you through. My learned friend made the submissions about what he said were attempts by my clients to block their refinancing. You were shown, just to clear up one particular aspect in relation to Credit Suisse. It's a minor point, but it's worth just making sure. So just so that you have it, you were taken, I think, to page 783, which was the sort of really the high point of my own friend's case on the Credit Suisse transfer. And you will see that on the next page, you will find a letter of instruction that had been provided, which is simply for transfer of those assets. So that gives you a bit more context about what's being asked for. It's just transfer. But one thing that has got a little bit lost, so my learned friend says, well, the bank dragged its feet over this instruction. But as the evidence of Mr. Hubscher explains, and as the next document shows, if you go to page 785, the initial instructions had to be revised And so it's not until the 30th of December that the revised instructions come through. So if the case is that they gave the instructions on the 16th or earlier of December, and those weren't complied with, that's just not true, because you can see that and Mr. Hubsher explains it in his evidence, and he explains it at page 775, paragraph 12. And in fact, my learned friend read that out to you, where he says that the problem was the initial instructions did not include, I think, the Apple shares was what he suggested. But in any event, it's not until the 30th of December that you get to the instruction, the actual instruction. And by 31st of December, of course, the first defendant's in margin breach. And the other point is that there is then this coupon problem, because the Lansdowne bonds haven't produced the coupon. And so my own friend told you no explanation was given for why there was a problem with the Credit Suisse. That is not accurate, because I showed you, I think, the page 398, where at paragraph 4, the bank explains why they're not going to go ahead with this transfer. And it's because credit approvals have not been given pending receipt of the coupon, which was still in discussion, and they can't commit until then. So it's all about margin at that point. In relation to EFG, you were shown a passage from Dr. Khan's statement. You weren't taken to the document he refers to. So I will show you that very briefly, if I may. It's on page 702 is what you were shown. And you were taken to this paragraph 3.49.
Sorry, what page? 78?
702.
Oh, so 702. Sorry.
Yeah, I think I said 702.
702. Yes, which paragraph?
You were taken to paragraph 3.49.
Yes.
And where Dr. Khan had said, suddenly Mr. Sani sent an email stopping the transfer of the securities and requesting the first defendant to first address the margin shortfall, either by sale of securities or by SWIFT confirmation. I received this at 22:14 on the 11th of February. You see then the footnote references to document BCH 1431. You find that document at page 548. So the allegation is that this is the email where they said, the bank said, no, you can't do a transfer. And you can actually see, if you read that email, it doesn't say anything of the sort. It says, we've shared all the below information with our chief risk officer. This is on page 548, 2/3 of the way down. However, he's refused to hold the sale of securities till portfolio transfer next week. So again, you've got a sort of Chinese whispers going on. You've got a kind of explanation of a document which doesn't say what it says, and that makes its way into the defence, it seems. And then there may have been a genuine misunderstanding, but it's quite difficult to see how this could really be misinterpreted, because in the context, they're clearly talking about whether or not the bank is going to go ahead and liquidate security. And so Your Honour raised, when my learned friend was dealing with this, Your Honour raised the question, was this a sort of chicken and egg type scenario? I think from the bank's perspective, no. The answer is no. If there'd been some, there surely should have been some base ability to structure a deal which involves commitments that the bank could accept, that it was going to receive payments if and when it transferred. And, you know, in one sense, one takes a risk on the bank that's going to pay, but as long as they are of suitable standing, then of course you'll accept their commitments to that extent. The problem was that it just never arrived. It never arrived. Nothing like that ever arrived. I'll move on from there then, very briefly, just 2 or 3 other points. Firstly, on the so-called misrepresentation issue, just to be clear, there is no claim, legal claim against the bank for misrepresentation. There's no suggestion in any of the pleadings that the bank has done anything that has breached some sort of tortious duty that amounts to a misrepresentation. We make a misrepresentation against the defendants, but that's not for today. I listened with interest to my own friend's submissions on quantum and this issue about the inability to sell the bonds. So my own friend said, well, it's a feature of the duty of good faith, I think was how he was saying it. But again, I mean, you would need to think that there, even if that duty existed, we say there's nothing to suggest that it does, you would need to be satisfied that a bank.
Well, there is an equitable duty, isn't there, to if you're selling.
If we're selling, yes.
Yeah.
If we're selling, but there's no duty on a lender to realise security.
No.
And there's no duty to of good faith which could generate that sort of duty. I accept if you're holding somebody else's assets and selling them in that way, then there will be duties associated with that. But there's no breaches alleged in relation to that, save for the failure to do it.
Yes.
So you need to generate the obligation. But you know, one just has to ask the question: a bank who goes to market, tries to sell a bond and is unable to do so, can that possibly be characterized as bad faith in any world? What my learned friend needs is an absolute duty to sell the security. In other words, that we take on the risk of not being able to realise the value. It's not commercial, and there's nothing in the contract to that effect. And then there was this suggestion that there might be some missing securities, and you were taken to those 2 pages and asked to look at them separately. And I think I made the point that one comes at the beginning of the trading relationship and the other comes at the end. And of course, during the course of that process, just to meet margin calls, you saw in some of the correspondence that certain of the liquid securities were realised. So one can take nothing from that. It's for the defendants to look at the schedule of assets and say, well, hang on a minute, we didn't sell there should be others, and this is where they come from, and these are but they don't do anything of that sort. And when it comes to valuation, Your Honour has the point. There's publicly available information. These are Bloomberg. I won't come back on the unauthorised communications because I heard what was said about that. And just very briefly on the approach to the law of Singapore, it is different from the sort of traditional common law centres in that sense, and you've got the submissions on that. But even in those common law centres, it's not going to be enough for a defendant to say, you know, I think there are implied terms here, but I can't tell you how they arise because I don't know enough about the law of Singapore or wherever it is. And so therefore I can just assert a legal principle in effect by implication, and then that's enough to get me off to trial. That's not in any system enough. So even if it wasn't like it is my own friend would be in a harder position if he was faced with the need to establish his case, to show that there's a real prospect of his case on Singapore law, because yes, the burden is on me. The legal burden is to show there's no real prospect of success, but I can show you the contract, and he then has to make out. He has the burden to then establish that there is an implied term there, or at least explain how he would do that at trial. And that, I think, the only other very minor point, you were taken, I think, towards the end of my learned friend submissions to page 564 of the bundle, and you are shown a page which was said to support the proposition that there was no margin shortfall. We don't accept that there wasn't a margin shortfall there. The point, though, in relation to this email is that these exchanges are taking place on the 17th of March, which is after the 11th of March, which is the date when the loans were called in. And that is why the response from the bank is in line with our communication dated 11th of March. Please make arrangements to repay all the facilities. So, in other words, nothing's going out of the account until we've got our money back. So I just wanted to make sure you had that in mind. Unless you have any other further questions for me, that's all I was going to come back on.
No, I don't. I thank you both. I will reserve my decision and let you have it as soon as I can.
Thank you very much.
Thank you.
Thank you both. We will now end this hearing.
Very good. Thank you.